Good morning. I want to ask everyone to please turn their cell phones to silent. You may notice board members accessing their laptops, phones, and other devices during the meeting. They are using these devices to access board meeting materials that are in electronic format. This is an official business meeting of the Medical Board of California. As such, disruptions of the board's businesses will not be tolerated. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask that person to conduct him or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by the moderator who will be facilitating the teleconference process. For those members of the meeting participating via teleconference, please wait until the moderator has introduced you before you make your comments. Each person will be limited to 3 minutes per agenda item. However, that time frame may be subject to change depending upon the number of speakers on each topic. During agenda item 18, public comments on items not on the agenda, the board has limited the public comment period for individuals on the teleconference to 20 minutes. In addition, public comments from individuals here at the meeting will also be limited to 20 minutes. Therefore, 20 minutes, no further comments will be accepted. During public comment on other agenda items, 10 minutes will be allowed for comments from individuals on the teleconference and those in the audience. After 10 minutes, no further comments will be accepted. Business Services Office staff will be assisting me with receiving the public comments via teleconference during this meeting. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or come forward and you will be recognized. I would like to request all speakers complete a presenter slip so I can call you by name at the appropriate time, that the record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slip to Ms. Cruz-Jones. Ms. Cruz-Jones, thank you. I will do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make a last-minute comment as well. I want to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. We plan to end around 1 p.m. today. I would like to ask Ms. Kirschmeyer to introduce any individuals in the audience.
I'd like to introduce Patrick Lee from the Department of Consumer Affairs, Deputy Director.
Thank you. I would like to call the meeting to order and ask that Ms. Cruz-Jones please call the roll.
Dr. Bolat?
Here.
Dr. Gonadev?
Here.
Dr. Hawkins?
Here.
Dr. Kraus?
Here.
Ms. Lawson? Here. Dr. Levine? Dr. Lewis?
Present.
Ms. Sutton-Wills?
Here.
Mr. Warmoth?
Here.
Ms. Wright?
Here.
Dr. Yip?
Here.
Ms. Pines?
Here. Thank you. A quorum is present.
Point of information. On agenda item 19, is that one agenda item, or do you anticipate soliciting public comment after each bill?
Yes, we will have public comment after each bill because we have action items.
Thank you.
We have 11 action items. Okay, thank you. I would like to remind the members again that we will be taking roll call vote on each action item. Moving to agenda item 18, public comments on items not on the agenda. Before we invite speakers to come forward, I would like to ask individuals making comments to not discuss pending complaints, pending applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications, as they would provide information to members that is outside of the record and in violation of the Administrative Procedure Act. Therefore, such discussions would be in conflict and lead to board decisions that could be challenged in the Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where decision is still pending. Board staff is available to speak to you about any pending matter. In addition, the board would like the public to address the board as a whole and not to individual members. Please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action item members can take is to listen to comments and decide whether they want a future agenda item on the topic. No other action can be taken on an item at this meeting. Though this may seem at times like the board members are not responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals or the board's mission. I have the following slips here. Hannah Ree, please come forward.
Yes, good morning, members of the board. Thank you again for allowing me to speak. So just wanted to properly introduce myself. I apologize. Yesterday I was quite tired, fatigued. In any event, so my name is Hannah Ree, R-H-E-E, Dr. Ree, and I'm part of a grassroots movement. We started a nonprofit organization. The nonprofit is called Global Health for Peace. And our mission statement is to improve the health and well-being of disadvantaged individuals through assistance and education by leveraging peace. So to that end, our first action, one of our first actions and movements is Black Patients Matter. And I would ask the board to possibly allow us a few minutes to discuss our concerns and kind of listen to some updated information. In addition to Black Patients Matter, having sat through a very informative session of the board yesterday and this morning, I believe that our nonprofit can provide some very insightful, productive feedback to the medical board, a perspective which is very recent, very current, very relevant, so as to leverage peace amongst patients, amongst board members, amongst healthcare workers, because our nonprofit will actually, we will be auditing previous medical board cases, looking at civil rights violations. And I believe that certainly we've talked about, myself has talked about race and ethnicity, but religion, my goodness, what doctor, what patient, what nurse does not say a little prayer before a procedure, a surgery, that sort of thing. So I'm concerned that perhaps it's time just to hear a little refresher about the importance of religious tolerance as well. And so it seems that I'm sure we all know, but we could provide a little updated information and that sort of thing. So again, I request the board to provide us a few minutes to listen to our insightful information so as to decrease the liability of members of the board as far as being sued and that sort of thing. And because at the end of the day, until they let us move to another planet, we all have to eat at the same table. So I think
Dr.
that...
Ree, your time is up.
Yes, okay, thank you.
Thank you for your comment. Are there any additional comments in the audience? Are there any comments on the phone?
Yes, the first comment is from Susan Lauren. Your line is now open.
Thank you. I'm going to talk about liposuction today. Liposuction is a part of breast reduction, breast reconstruction, stem cell harvesting, abdominoplasty, mommy makeovers, fat transfer for facelifts, and many other procedures. In Clinical Anesthesiology of October 4th, 2012, Michael Blessides wrote the article, As Liposuction Deaths Mount, Study Exposes Cracks in Safety. He said, a quarter century after the nation's plastic surgeons received what amounted to carte blanche to perform liposuction, a new analysis suggests that the procedure is no safer than it was back then. Making matters worse, the researchers said the surgery has been oversimplified in the public media, in the popular media. Throw into the mix an ample supply of seemingly unscrupulous physicians and state regulators who do not appear ready to crack down on them, and the result is a recipe for national disaster. The American Society of Anesthesiologists said that California's liposuction regulations do not prevent patient deaths, and the regulations specify requirement by volume of fat removed. These are too high. Patients die with even lower volumes. Liposuction has no medical benefit. The death rate is 10 to 20 times greater than other surgical procedures, and it causes other long-term harm. The procedure is financially driven, and those performing do not disclose the true risks involved. Many people are coerced into having liposuction through false imagery and strong advertising. Plastic surgeons and their boards put out propaganda and misleading short-term results regarding liposuction. In the interest of public safety, I propose that liposuction and body sculpting ads are banned, and California Liposuction Code 1356.6 is changed. The HTAC, a nonpartisan group formed to study liposuction harm, said, death and disfigurement due to liposuction should be a matter for serious public concern. They also said, since liposuction is an elective, pay-out-of-pocket procedure, data is not collected as to how many procedures are performed, the complexity of procedures, or the resultant complications. Clear, important statistics on fatalities and complications from private offices or surgery-owned surgery centers may be withheld. The increasing number of liposuction procedures has led to a growing number of iatrogenic fat tissue deformities, in addition to those of traumatic and disease-related nature. Chris Centeno, MD, says, harvesting fat is a violent affair. You need to first use a scalpel. The whole goal is disrupting large amounts of normal tissue. In fact, the stem cells, he's talking about stem cells.
Caller, you have reached 3 minutes. Please conclude.
Okay, thanks. One more sentence. Live around the blood vessels, so you have to chew up as many blood vessels and the fat as possible to get a good stem cell yield. And then he says you have to break apart large sections of tissue and break up large swaths of tissue with suction, sucking broken tissue and blood vessels into a syringe. You haven't seen invasive until you've seen a liposuction. So thank you for listening. This is a public health menace. I was harmed by it when I went for breast reduction, and I am asking to change these things, lipo code, and to ban ads. Thank you so much.
Thank you. Are there any additional comments on the phone?
Yes, the next comment is from Eric Andrist. Your line is now open.
Good morning. FYI, yesterday Dev gave Howard and Michelle 1 minute for their campaign speeches. I timed it, and it took each of them 2.5 minutes, and Carrie Webb, staff attorney, didn't cut them off. Also, you've all heard about these sexual assault cases at USC and UCLA. It's all over the news. How is the board hearing that information before an accusation filed different than someone talking about an open complaint? Juries are told that they have to keep an open mind and not consider anything they hear in the news during deliberations. Are your board members incapable of doing the same thing? So back to this new app that you're advertising, I feel prematurely, the core of this app is your very flawed Breeze website. Write these doctors' names down and try and look them up either on Breeze or in the app. Dr. Michael Feiz, F-E-I-Z, plastic surgeon in Beverly Hills, and Google him to make sure that's the name he actually goes by. And podiatrist Dr. Jerry Stein, and that's Jerry with a G, in Burbank. I guarantee you won't be able to find either one in Breeze or the new app. Look up Dr. Hossein Babali, B-A-B-A-A-L-I, who was ordered to a year in jail and to register as a sex offender. See what your app shows for him. Look up Rizard Chetkowski, R-Y-S-Z-A-R-D, C-H-E-T-K-O-W-S-K-I, who sexually assaulted 6 women during their pelvic exams in his infertility clinic. Your app will show no disciplinary action whatsoever. That's because the board gave him, for sexual assault of 6 women, a public reprimand, which disappeared after 10 years. How many ladies on the board would like to see Dr. Chetkowski after learning he sexually assaulted 6 women? How many think it's okay for the Medical Board of California that they choose not to warn consumers about him? And we have many more similar cases, just like the ones where consumers will not find any information about doctors who have harmed patients. And back to my point yesterday, in case you didn't catch it, Ms. Nichols told us that their main problem is caseload. So imagine if the board wasn't closing all the legitimate cases like mine without cause. Imagine if you had to investigate even just 10% more cases because they truly were legitimate, but they are already overloaded with the caseload they have now. How is it even feasible that they could investigate all the legitimate complaints? Doesn't it make perfect sense that you're closing legitimate claims just to keep from having to work on them and weigh the caseload down even more? And further, you have no incentive to discipline doctors because this board's income is derived from those very doctors' license fees. It's an automatic conflict of interest. Right, Deb? Right, Howard? It's no wonder you're giving doctors like Dr. Daniel Hedrick, who overdosed Tim and Tammy Smick's son to death, a public reprimand because his license fees helped to run this board. You bartered away death charges so you could give him a public reprimand. Right, Ronald? It's truly disgusting. You should all be ashamed instead of patting each other on the back. We're watching, and we will continue to expose. And don't you think it's strange that your executive director, Kimberly Kirkmeyer, does nothing to try and mitigate all this animosity? Don't you think that would be part of her job description, considering how much money she makes? Thanks.
Thank you for your comment. Are there any additional comments on the phone?
Yes, there is one more comment in the queue from Virginia Farr. Your line is now open.
Hello?
Caller, are you on the line?
You hear me? Sorry.
We can
Hello?
hear you.
Okay, sorry. Just a second. Let me get to my other paper. So, professionally, I have interacted with many doctors on professional level that were amazing. I've changed many system-wide hospital protocols. Yet as a patient, after I experienced a medical error, I find response highly concerning. It was not the error that harmed me, it was the after effect, including denial, care for months, and intentional omissions from my medical records. At one East Bay facility, you would not be able to know my medical course. In addition, I was slandered and gaslighted. Sorry, this is very hard for me. My privacy was violated. After 8 years, I still have not been able to correct my medical records. I went from making over $100,000 a year to nothing. I've lost $600,000 in my life. I'm 48 years old. That was nothing. Not from the medical error, but how it's covered up. While it started with a fixable error, it is a wall of silence that caused the harm. The result, I was not able to sit for 3 years. I had over 20 injections for pain. It took over 20 pelvic exams by 50 medical professionals to resolve the pain. 90% of those doctors either covered up the issue or did the same thing as the other doctor. Only 2% actually knew how to assess a pelvic floor.
requesting topics added on the agenda that include women's pelvic health, since my experience with a significant lack of knowledge in this area. Trauma-informed care, as patients with trauma are labeled with inaccurate labels and the trauma is not addressed, and these labels cause additional harm, and trauma also causes additional harm, as we know by the ACE study and more recent studies on trauma. I'm also requesting agenda on open notes so that patients can ensure their notes are correct, along with a topic to resolve the wall of silence. I have no intent on bringing legal action against the doctors that did the error. Yeah, my life was destroyed from the doctors covering up for each other, and this is not acceptable. And the wall of silence causes extreme harm when the patients are gaslighted when requesting proper information about their illness. They have the right to know what is going on with their body, what happened, and how to fix it. And I should have never went through what I went through. And I had no trust in the board, so I did never turn my case into the board, because based on the other cases I've seen, you guys have done absolutely nothing to help people like...
Caller, you have reached 3 minutes. Please conclude.
That's it. I would appreciate if you did something instead of this medical mayhem that's going on in California.
Thank you for
your
your
lack of
comment.
ability to enforce laws are causing doctors not even try to be safe. So, thank you for putting me on the agenda. Done.
Are there any additional comments on the phone?
I'm showing no further comments at this time.
Great. Let's move to agenda item 19, update, discussion, and possible action on legislative regulation. Ms. Simones, we have about 11 action items today. Okay.
Okay, so please refer to tab 19 in your board packets and the tracker list. On your tracker list, the bills in blue are either two-year bills or bills we have already taken positions on, so these do not need to be discussed at this time, unless you have questions. The bill in pink is the board sponsor bill, so we'll go over that bill first, and the bills in green will require discussion and a position. So the sponsored bill update, I believe you all got my email, but AB 2311, the bill that the board is co-sponsoring with the UC Office of the President, was signed by the governor, and so it will become effective on January 1st, 2019. So with that, let's move on to the first bill in green, unless anyone has questions, AB 18. So first, I would like to provide a little bit of history on this bill. So the Licensed Physicians and Dentists from Mexico pilot program was established by AB 1045 in 2002. This bill authorized up to 30 licensed physicians specializing in family practice, internal medicine, pediatrics, and obstetrics and gynecology, and up to 30 licensed dentists from Mexico to practice medicine or dentistry in California for up to 3 years. The bill required individuals to meet certain requirements related to training and education. Physician program participants are required to undergo a 6-month orientation program approved by the Medical Board of California prior to being approved to come to California. The board's role in this program is to provide oversight review of the implementation. However, AB 1045 required that all of the funding necessary for the implementation of the program, including the evaluation and oversight functions, must be secured from nonprofit philanthropic entities. The law expressly states that implementation of this program shall not proceed unless appropriate funding is secured. Only a small amount of funding has recently been secured for this program, so it has not yet been implemented. AB 18, this bill would make changes to the section of law related to the orientation program. Currently, the law requires the orientation program to be 6 months and to address medical protocol, community clinic history and operations, medical administration, hospital operations and protocol, medical ethics, the California Medical Delivery System, health maintenance organizations and managed care practices, and pharmacology differences. This orientation program must be approved by the board to ensure that it contains the requisite subject matter and meets appropriate law and medical standards where applicable. The board will be presented curriculum for approval for this orientation program later on today. So this bill would amend existing law to strike the 6-month requirement for the orientation program portion. So it would still have to meet all the other requirements in the bill. It just strikes the 6 months, so it could be any length as long as it meets the requirements in the bill. The interested parties believe that the orientation program does not need to be 6 months and can still meet all the requirements with a shorter orientation program. It is important to note that this program allows physicians to come into California and practice without postgraduate training, thus the importance of this orientation program. So with that, I would like to open it up for discussion by the board for a position.
Are there any questions or comments? Dr. Gananadev?
This was a concern even before. That is 6 months of, I guess you can call, a little supervised internship. You get to practice compared to minimum 3 years of residency for anybody, anywhere, coming from anywhere in the world. And taking even that 6 months off is extremely concerning for patient safety. Usually, these people will be practicing in underrepresented minority areas, so that concerns me a lot more, so I have a serious concern.
Dr. Yip?
I think it really take away 6 months, at least something, not just like no time period, because it's hard to define how to be a successful orientation. Depends on the organization. Particularly, they were trained in different areas, particularly pharmacology, the drugs are used. One question I have, would the federally qualified clinic be qualified as a non-profit entity that actually would have funding to employ or take on these physicians? Because it seems like those clinics are the one who maybe quickly have a budget for so-called donation, and also they may be in those underserved area too.
So there are already clinics that are interested in doing this, Dr. Yip, and they do meet the requirements that's laid out in law. I see Carrie's looking at the section, but there are those out there that are going to meet the requirements that want to do this.
And they have to be approved by the board, right? They come to us for approval.
Yes, they come to us, yeah.
Dr. Hawkins?
So I share Dr. Gandev's concerns as well. I would be reassured, however, if these clinics offered a supervisory function such that these individuals who did not require at least 6 months training were supervised. Otherwise, I have difficulty with it as well.
So the program as it is right now does not require that supervision. Basically, just backing up a little bit, the law right now has already been passed for the program that allows the individuals, they do that 6-month orientation program while they're still in Mexico. Once they complete that, then they come, they apply for that license, get the license, and then they come and they work here just as any other physician and surgeon would here in California. So that's what the law authorizes right now. But to your point, what you're looking at is if they remove that 6-month requirement and it's any time frame for that orientation program, do you believe that that is enough education for those individuals prior to coming to California if it's not limited to 6 months? So that's kind of what you're looking at right now, but there isn't any supervision for them.
Are the orientation on site? Let's say Ultimate hired the doctor. Are the orientation within Ultimate, or what is this orientation
So
program?
the orientation program, they actually have to complete before they come to California. We're going to be talking about it a little bit later. It's in your packet. It's under agenda item 23, I believe, or 22, I think. But anyway, it will come before you, but it's a distance learning program, and so it's been established by one of the clinics here that is actually a ACGME approved program by Joint Commission, and they put the program together with the UNAM Medical School in Mexico. And so the program is something that they will do before they come to California. And it's kind of like a learning on their own through this distance learning program.
Dr. Kraus?
It's my understanding that this program has existed, and I'm wondering if there has been an analysis of the results of the program.
So it hasn't existed, even though the legislation passed in 2002, which would have made it, I believe, effective 2003, we've never had the funding to do the program because it all has to be done by philanthropic entities, and we've never received any money to start it. So just as of late, we've received money to start trying to get the approvals for the program to be set up. Now, once the program is established and we've gone through the process, there's an evaluation evaluation process that will be contracted out by the board for a third-party entity to evaluate it, from patient surveys to everything with the program, but that has not been done to date because it's not started.
Dr. Bolat?
So, I was aware of this bill back in 2002, and I can see how it's changed over time. And as a person who's interested in providing care to under-resourced communities, I'm also concerned about two-tiered systems. And I say that in this way, that for a long while, John Tudor Hart back in the 70s coined the term the inverse care law. And the inverse care law says that where there's poverty, where there's places that are not desirable to work, that's not where we find physicians. And so this program for the Central Valley, I believe, has a difficult time, allegedly, right, factually, recruiting physicians, despite the fact there exists which states in the document, the Natividad Salinas area, a residency training program. So my concerns are that the program itself, we always have this idea in medical education, where you train, you'll stay, but that hasn't panned out for that particular program. The facts are, we have, as medical educators and individuals that are providing licensure, rely on individuals to pass the United States Medical Licensing Exam number 1, Basic Science, United States Medical Licensing Exam number 2, Clinical Knowledge, United States Medical Licensing Exam, Clinical Skills, and subsequently, United States Medical Licensing Exam, Step 3. Despite I'm sure the physicians around the table, we didn't take USMLE, I think they were called NBMEs, but despite people grumbling about it, the fact is that's what licensing here uses as a proxy of whether or not a license will be provided. So I understand the need to fill the gap. I'm concerned particularly would not agree with not having this bill without having 6 months, but I also am concerned about what that 6 month entails. Understanding the healthcare system of California is not the same as clinical medicine, and that's not what the doctors are doing. Understanding Medi-Cal managed care is a fine idea, and that's usually what we do in the senior year of residency. And then my final comment is, if the facts are that we are working towards individuals having a minimum of postgraduate residency training, I would remain concerned of a two-tiered system. Thank you.
Thank you. Are there any other comments or questions from members? I have a question. Is there a minimum amount of orientation that they have decided that it would take?
That's the 6 months right now.
So the
by
6 months
statute.
is the minimum?
That's the minimum, yes. But the program itself, when they put the program that you have before you, it could be probably a lower than 6 month program, the way it's been established.
So, I mean, so hearing that there are some concerns here, kind of our options are just to oppose it because we believe 6 months, it should be at least 6 months, right? There's basically no amendment, no amendment under 6 months that we'd be okay with. Or the other option is to oppose and less amend, and you would pick an amount of months that you think is sufficient, like 4 months or 3 months. But what I'm kind of hearing, and correct me if I'm wrong, it sounds like everyone kind of feels that 6 months is the minimum amount, if I'm wrong. And that would really be an opposed, because that would be basically keep the law like it is, that we think 6 months is appropriate. So I'll open up to the board, but it sounds like our options are kind of oppose or impose and less amend position, and picking an actual amount of months that we would request as an amendment.
Can I have a motion to approve based on staff recommendation?
Yeah, I make a motion to oppose. And I just want to, just a discussion, do we have a second? So the discuss is that compared to when this law was passed, there are two more new medical schools in California. One third one is coming up in 2020 at Kaiser. There are multiple more residencies, and Dr. Bollard's program at UCLA to really encourage these international graduates to get into residency is wonderful, and we're the same board who increased the residency requirement to 3 years for them to get a license, and we are allowing these people to practice for coming from another country without any training. It makes no sense.
I do just want to point out, I know they don't have U.S. postgraduate training, but they are board certified in that country. That is, just so you know all the facts of it. They do have to be licensed and hold board certification equivalent.
So are every person, a lot of people who come from Europe,
I know.
who come from China, who come from India. So a lot of these people have in their own country training, but we still have to let them go through the entire program.
Are there any other comments from members before I go to the audience? I have one slip here. Rosa Fernandez, please come to the table.
Yes, good morning. I'm Rosa Vivian Fernandez. I'm CEO of San Benito Health Foundation and a fellow of the American College of Healthcare Executives. And I would urge the board to support this bill, and you'll have later dialogue about the curriculum. The curriculum content will not be changed, and it's the curriculum we're speaking about is the initial curriculum prior to these board-certified individuals from Mexico coming to our organizations. All of our FQACs, many of them are actually Joint Commission accredited. Natividad Hospital is a residency program that will be onboarding with us, and UC Davis as well. And they will continue to receive mentoring and partnership with the Natividad program while they are here. But I want to reiterate that they are practicing clinicians in Mexico. They are experienced clinicians in Mexico, and this can serve as an exchange program to meet the needs of the underserved in the state of California, which we are in critical need that are not. These needs are not being met by any of the medical schools currently, and not being met by the J1 process at all.
Thank you. Are there any additional comments in the audience? Dr. Ree?
Yes, thank you. So I have a few concerns about this bill. First is that I would wonder if perhaps it may be necessary for them to undergo diversity training as far as treating patients, treating non-white patients, and then also religious tolerance. We have such a diversity of folks in the Central Valley area. I know this because I work there. I go into thousands, probably by now thousands of homes of patients in the Central Valley. I'm very familiar with the population there, and I'm very concerned that with these physicians coming in, perhaps it may be necessary to have some training in diversity, so as not to marginalize non-white patients in the area. And then secondly, so as far as the inverse care law, certainly there are, the statement is quite true in several places in the state of California. However, in the Central Valley, we're actually very blessed with a diversity of ethnically diverse doctors. Why? I know this because I'm there, and I know the doctors in the area. They graduated from foreign medical schools overseas, went through the process, and are doing quite well. So I'm wondering if perhaps by passing this bill and having physicians from Mexico, if we're marginalizing other ethnicities, other physician doctors who are already working in the area. And so a question that I would have is these clinics. So if we have a clinic and we have physicians from, in this case, Mexico, are they going to see patients that are non-white? Or is it exclusively Mexican patients? I don't know. Is that a question? It is for me. Is it a concern? It is for me. So I have some questions and concerns about how this could be addressing or not addressing diversity.
Thank you. Are there any additional questions or comments from the audience? Are there any comments on the phone?
I'm showing no comments at this time.
Okay. Ms. Cruz, let's take a roll call.
Dr. Bolat?
Sorry, what was the motion is to oppose the bill.
To oppose.
Aye. Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes, opposed.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Aye.
Ms. Pines?
Aye.
Okay,
The motion was for.
great. Moving on, and the next bill is AB 505. This bill would allow an administrative law judge to extend the deadline for the exchange of expert witness reports upon a motion and based upon a showing of good cause. This bill would specify that the ALJ may extend the timeline for a period not to exceed 100 calendar days cumulatively, but in no case would this bill allow the exchange to take place less than 30 calendar days before the hearing date, or whichever comes first. In the governor's signing message for the board's sunset bill, he stated that two issues needed further review, and one being the exchange of expert witness reports regarding a doctor under investigation by the board. The governor in his signing message directed his staff to work with the legislature to determine what changes are needed. Board staff met with the governor's staff and interested parties and provided technical assistance, as concerns were brought up that ALJ should be given more discretion to extend the timeline of the exchange of reports for good cause. The language included in this bill is a result of those meetings and will allow ALJ some flexibility to extend the deadline, but will still place reasonable limits on the extension. Since board staff provided technical assistance, we're suggesting that the board take a support position on this bill, and I need a motion.
I so move.
Second.
Are there any questions from the members? Comments? Dr. Bolat?
Now, forgive me if I'm getting my lanes on all of these timelines we were discussing yesterday.
Right.
We have many, as we heard from Ms. Castro and Ms. Nichols, many ways in which the process can get
Right.
delayed.
Right.
And one of the other areas, of course, and then I'm just speaking from my experience, having been an expert reviewer, there's a lot of that goes into that, right?
Right.
So now this could add an additional 100 days, and maybe you can help me understand why this is important. What happens?
So basically, the governor's office directed his staff to work on this issue. There were some concerns brought up at the end when our sunset bill was going through, and this was kind of a commitment that the governor's office made in exchange for letting our bill, pass through the process. And so there was concerns that, like, in the event of an emergency, like let's say, for example, the person got in a car accident on the way there, or there was a fire and they couldn't show up. The concerns that were brought up is right now ALJs have no flexibility, and there would be in this emergency situation. Now, we kind of already believe that the ALJs do have this flexibility, because we use the example of the fires, for example. Of course, they got, extended, the deadline got extended because people couldn't show up because of the fires. But so we worked with the stakeholders to come up with some way to show it in law that they have this flexibility, but also put reasonable limits on it, so it couldn't be like you're saying, Dr. Bullock, just keep on getting extended and extended. And I don't know, Carrie, do you have anything to add to that, or Kim?
I think that's exactly right. We were directed to do this.
I see.
And we came up with a compromise that we thought we could live with, and that's what you see before you.
And this doesn't change the fact that an ALJ can already extend a hearing date.
Right.
This is just dealing with the exchange of the expert reviewer report. So it can already extend that time. It's just that we would get the expert review report earlier, the way the law is currently written. This changes that a little bit, so.
Are there any additional questions from members? Okay, are there any comments from members in the audience? Ms. Castro?
Good morning.
Good morning.
On the issue of timelines, Dr. Bola, you hit that nail with that hammer. The late disclosure of expert opinions and testimony descriptions adds delay to the early settlement of medical board matters. Although the Administrative Procedures Act determines the exchange of discovery, it does not allow for a meaningful and early reveal to our retained expert of the defense that is to be proffered either in settlement or hearing. We have no ability to depose that defense expert, which is really odd for folks that are civil litigators. We don't know until we know, and the later we know it, it just really delays things. The Office of Administrative Hearings had been on the correct path of holding defense counsel and clients accountable for early disclosure to their licensing agency of the defense expert testimony. And while we respect our Office of Administrative Hearing judges, and as our client, Ms. Kirchmeier, has aptly pointed out, they've always had the right to kick the hearing date in order to give someone a chance to delay the hearing. At the same time, we were very pleased at the Attorney General's office that we could see this defense expert report 30 days before the first settled hearing date. It is very, very common for respondents to delay the hearing date. Why? Because in the absence of a suspension order, and in view of the fact that they may know from their defense expert that they will lose their license if they go to hearing, and that perhaps the best outcome should be surrender, some of those respondents will choose to kick the hearing date as long as possible, not do that reveal for as long as they can, in order to perhaps wind down their businesses that they will have no choice but to close, either through a stipulated surrender or taking their chances at hearing and losing their license anyway. So really, the flexibility to allow a doctor to stay in practice longer is what we're talking about. And even though many of them will not avail themselves of the hearing and will surrender their licenses anyway, it's an erosion of something that we thought was really, really good for your cases and your timelines. Thank you.
Thank you. Are there any comments from the audience?
Ms. Pines?
I do want to point out that while the hearing date can still be kicked out, there is kind of a limitation on this. They can't get more than 100 days, so a little over 3 months to delay the expert exchange. So, we did do our best to corral that and still meet the directive that we were given.
Okay, thank you. Ms. Wright?
I have so many questions about this because it's just got really confusing for me listening to it from a litigator perspective. So if there's a delay, why would the Attorney General's office be prohibited from, and maybe Ms. Castro can come back and talk about this, why would they be delayed in conducting discovery as to the expert and taking a deposition of the expert? There should be no prohibition for that, because civilly, you have 15 days before your hearing or your trial to still take the deposition. What's happening here?
I'm sorry I wasn't clear. We do not have any deposition rights.
Okay, you have no deposition rights.
No deposition rights. And in the exchange of discovery, we already have everything.
Okay.
Especially in the vertical enforcement process. We've already really gotten everything we need to know with your power under investigational subpoenas. Interrogatories, obviously the subject interview, which is where we get the doctor side of the story. The only thing we do not get as part of discovery, usually because as a defense counsel, perhaps your client has not retained you and hasn't paid a little extra for now to move into the trial mode, right? So they haven't retained experts yet. They've just agreed to file a notice of defense, exchange discovery. So not until the client actually knows that they may go to hearing, then that's when they will parlay out that money to retain an expert, to give a verbal opinion, then decide, okay, what am I going to do with my case? If it looks like they're going to posture it for hearing, then fine, that they'll have to now at least write a defense expert report and give more than they did in the past. I recognize the efforts of the staff, obviously, and how these things really do work out as compromises. We're all here to compromise. But my point is that the earlier we get expert disclosure of what they're going to say, it allows us a more meaningful opportunity to recommend to our client what she needs to know if we go to hearing and what the likelihood of success on the disciplinary guidelines and the ranges, therefore, on that accusation are. We also show that defense expert report to your retained expert in your cases, and then that's where we will, by that point, our staff has prepared our testifying expert, has put it in their head that they may be testifying, and so we're running with that defense expert report to our medical board expert and asking them, hey, this is what they're going to say if we go to trial. Does this change your opinion or not? And obviously, we want to make sure that our experts have considered everything. We don't want to find out at hearing, and it is a good tool for settlement. Settling cases saves timelines as well, especially if we're going to get a very good settlement. Either way, it just saves time. But many times it sounds like they want to go to hearing. They avail themselves of delaying that ultimate thing. I understand emergencies. Obviously, they happen. They happen to us too, and from time to time, we have to come in and request a continuance. People get in car accidents, and we request continuance. We understand good cause, and I think that the Attorney General's office does already a good job to not be draconian. There will be no problem. Obviously, if that's what it is, we will talk to our client, see if we can get her permission, and stipulate that, yeah, this is terrible, the person's wife is sick or whatever. But in other cases, I must admit that sometimes it's not readily apparent to us that the good cause should be good cause, but obviously we respect the opinions and judgments and orders of our judges. But not having money or posturing to delay and retain your license as long as possible before the ultimate decision makers have to make their decision either by hearing or settlement adds timelines. And even though, yes, it is only up to 100 days or 30, whatever's less, it's still time that you're adding to your cases. But I understand if it has to happen, then obviously we'll work with it. But my only point is this, it does erode some of the gains that we had seen.
So I have a simple question. Does this bill place an onerous on your office or no?
I'm sorry?
Does it place an onerous, do you feel like this would be burdensome? Does this bill?
No, we can do this,
okay.
Obviously. I mean, they're your cases. It's not going to be onerous. It's just, my point was that the administrative law judges had made the proper decision to deny respondents who failed to comply with this rule. And the rule applies to us too, by the way. So if we fail to disclose this 30 days prior to the originally scheduled hearing date, then we are out as well. However, with that point being made, it's just, I think I've made my point clear. That it's not onerous. We'll do whatever they want. We'll run it by our client, obviously. We would stipulate if there was something that we felt was good cause and not waste the judge's time with. And so we were really commending our administrative law judges because this gets out in the defense counsel community immediately. Anytime an administrative law judge takes that measure, and it's almost like a terminating section. You cannot bring in an expert, and nothing would move parties closer to settlement if you can't have an expert. So, the ALJ, we commend the ALJs that took that important step, and this is the result that, they're going to now go back kind of to where they were before, which is not giving us the information that you need to make a proper and intelligent decision as early as possible.
Thank you, Ms. Castro. We appreciate that.
And before we move on, I just kind of want to clear up that all this does is give ALJs flexibility. So we believe they already have this flexibility to do this now. Like if there was a fire or something, they could do this now. This is just basically putting that flexibility in law and putting some time limits around it. So it wouldn't say that they had to offer this if they didn't believe there was good cause. It just allows them the ability to do that.
Can I clear something up?
Yeah.
And I just want to clear something up before Ms. Feldman speaks too. So many of you may remember it was our sunset bill last year that changed this law that got us to where we are, because we had taken some recommendations from the AG's office and in our discussion about how our cases proceed. What was happening is the expert for us, we give over our expert opinion immediately upon discovery because we have it. Otherwise, we wouldn't have a case. The defense does not do the same, and so we were trying to make some similarities between us and what the respondent physician could do. So we changed the law last year to say that they had to turn over that expert report 30 days before the first noticed hearing. That's what the language changed it to. Before that, it could be within any hearing. So before, what was happening is they would say, okay, you have to turn it over 30 days from hearing. So let's say the hearing was set on March 1st. Then let's say defense went in and got the hearing continued to August 1st. Now the date of when we got that first expert opinion changed from, February 1st to now July 1st, okay? If it got moved that far, that's when now that expert opinion would come in. So we said, no, we want it to be that first date and hold to the first date always. So that's how the law changed. But the governor's office, when they actually signed the bill, put a signing message on it that said, we want you to still talk about this because there's still a lot of controversy around it being from that first, because we don't believe that if there was a true good cause that it should hold to that 30, like there was an accident and the expert couldn't turn over their opinion because they got in this car accident. So that's what the signing message was. So we went back, and as Ms. Webb has really pointed out, this is the language that massaging it and going back and forth. So now basically they can still continue the hearing. The time will still continue. It doesn't have to be 30 days from that first one. It's going to be now, you can continue it, but it still has to be before that first hearing, but it can only be extended up to that 100 days. Now from that first needed date. So from February 1st when we need it before, now it's going to be up to that another 100 days past that. So I hope that clarifies it for everyone, kind of what's being changed here.
Yes, I think that was clear. Ms. D'Angelo?
Thank you. Julie D'Angelo Felmuth from the Center for Public Interest Law, and I'm the former Medical Board Enforcement Monitor. I just wanted to give you some background information because this is not civil litigation. There are no depositions in the administrative process. Everything is geared toward the hearing. The only time there can be a deposition is if a witness is not going to be available at the hearing. Prior to 2005, when this law was enacted requiring the exchange of expert witness opinions, as Ms. Kirkmeyer said, the medical board always required its experts to put their opinions in writing, and those would become immediately discoverable by the defense. The defense counsel would routinely instruct their expert witnesses not to put anything in writing, which led to two things. The ambush of the Deputy AG at the hearing, because the Deputy AG had no knowledge of the basis of that expert's opinion whatsoever until the hearing date. And the second consequence is there was no real reasonable prospect of settlement, which we all want. We want settlements. We want settlements to occur and to speed up the resolution of these actions. So we drafted this law in 2005 to require if any party wants to use an expert witness at a hearing, they have to exchange that expert witness opinion 30 days in advance. I agree with Ms. Castro's concerns that this bill, although it will give ALJs flexibility, and it's not completely catastrophic, it will extend the hearing timeframes that you all have expressed so much concern about yesterday. So I don't support the bill, and I agree with Ms. Castro's concerns. Thank you.
Thank you. Are there any additional comments from members? Any additional comments from the audience? Any comments on the phone? Was the phone going on?
Any comments on the line? Hello?
No? Okay, we'll move on. We have a motion to support AB 505. Dr. Donovan?
Thank you. Jennifer just took a question that is the governor's office and all parties are set on that 100 days, or can it be shortened?
Well, this was the negotiation. This is not what, 100 days is not what it started out with. So, that's kind of what all parties agreed to. So, obviously we put what we would like and they put what they would like, and this is how we met in the middle. So, you have anything to add to that, Carrie or Kim?
Only that you all are the decision makers. So we responded to a directive, and now it comes before you to make the decision, and we made no promises to represent what this board would do.
Yeah, we were very clear in those meetings. We're providing technical assistance. We still have to take it to the board, so.
Members, are we changing our mind? Are we still we have a motion to support?
Yeah, support is fine. I'm just wondering if we can ask for a shorter timeline. That's why I asked that question.
Okay.
I mean, that's an option that's available to you. Right now it's 100 days, so shortening it to 90, 60, whatever, that is an option.
So we would just, take a supportive amended position, but we'd actually have to pick a number of days so I could go back and say, our board wants it to be 90, or like Carrie said, whatever you think is appropriate.
Can I ask a question? Right now, the ALJ's position would be they could extend it for 250 days if they wanted to, right? Is that their position? I mean, the current state of the law is...
Not the way the law currently is, because it says because of that first hearing. So for the expert testimony, it would have to come in 30 days before the first hearing.
Right, but what I thought I heard was that we believe they have the flexibility to make this extension already for emergency
so if there was a drastic, yes, that's what we believe. There's a case law, Mione decision, that was our board's decision, that basically it says right at the bottom, there's a footnote that says this can be extended for, I can't remember the exact wording, but for good cause, basically.
It's, impossibility.
Right.
Essentially. So it would be, if there is something that tragic or serious that happens that makes the exchange not possible, then the ALJ can extend it. But I do know that the attorneys work with each other if there's good cause to stipulate to an extension, but don't want that to be abused. And that's why when the sunset bill went through, it was very strict, because the board's been concerned about timelines, and this was a tool to move it on and foster early exchange and settlement possibilities. We got the directive, and this is what we came up with, and now the board can.
And Ms. Lawson, we actually walked in with, we think you can already do this, there doesn't need to be language. That's how our first negotiation started. So
I guess my sense is we're really in the weeds with this legislation, and even if we put in place shall not exceed 100 days, they likely could exceed 100 days for some emergency exception, correct?
Absolutely right.
I think that the legislation provides a guideline for what's considered reasonable, and so to the extent that it does cause a burden to our enforcement to have the exchange occur 100 days after it was anticipated, which would have been within the 30 days before the first scheduled hearing, to have it potentially be 100 days after that could, for a litigator, be substantial. And so to the extent that, and again, Ms. Castro, if we can just have a short statement on what makes sense in terms of litigation, losing that 30 days within the time frame of this first scheduled hearing actually does sound like a change that might not be reasonable. It does seem onerous. And so to the extent that, again, while the ALJ does have impossibility to, once you change this, it just changed the definition of what's reasonable, it makes a guideline for measurement, and so we should be deliberate on what we decide. Did Ms. Castro leave the room?
I didn't hear a second.
There was, yeah.
There was a second.
Yeah, actually Christina was.
I seconded it first.
So, I mean, at this point, you could ask for a friendly amendment to the current vote that's on the table. And if you want to change it to 60 days, 90 days, something like that, and then it would be a support if amended rather than just a support position.
So, I think that support, if amended, with some discussion with Ms. Castro, too, if that's possible, to talk about the...
Well, we would need a time frame today to be able to take it back. So if you think that it would be 60 days, then, and especially since the I think, Ms. Castro, what they're looking at is what is and Ms. Castro has given me a signal of 30 days, which, I mean, we can put that in there, but that's not going to happen. I can tell you that right now.
So,
you know, I think we need to
45 days?
I mean, this is where I think we're getting really in the weeds, and the administrative law judge already has the flexibility to make modifications to this. So, I mean, I can appreciate that we want to provide this very clear directive about their process, but they're going to have the flexibility in this process to make.
And we did work really hard on this language to get where we're at now, which doesn't mean we can't take it back, but I think I need to come back with something reasonable. 30 days is going to be a no-go.
And what about a neutral position? It sounds like we can't all agree on this, but the governor did direct us to take a look at this. Our staff took a look at it. So the next step is, I mean, if we disagree with what the compromise has come up with, I think we can either oppose it or be neutral, but trying to get in the weeds and negotiate from here.
I would rather not oppose it. I mean, neutral or support if amend, or a neutral if amend, if we have an actual amendment, or like you said, we could just go neutral.
I'm in favor of supporting if amended, but I think that the measure of reasonableness being 100 days is a problem.
Okay.
And so
I would actually recommend 60. If you're going to go back with something that looks reasonable from the board, I think 60-day extension, like Ms. Lawson said, you already have the ability to take it. The ALJ has the ability to change that if they don't like that, and 60 days is kind of in the middle with, and you're extending, again, the hearing could already be extended 180 days. It has nothing to do with when that next hearing's set. This is just the exchange of that expert report. So you're basically, by saying 60 days, you're extending settlement negotiations 60 days is what you're doing. Because the problem is that we can't start settlement negotiations until our side knows what we're settling against, right? We need to see that expert to see
It's
what
not an automatic extension. It's only allowing ALJs if there's good cause, if there's some kind of situation that comes up, and you're just allowing them that flexibility. So it's not going to be every case is delayed 60 days.
And it still has to be good cause.
Right.
And we didn't define good cause.
In order to advance the discussion, I'd like to amend the motion to support if amended to 60 days.
Do you have a second?
Second.
No, I'm the one who made the...
So Dr. Lewis,
you have to.
Me to make the...
Do you agree to the friendly amendment?
Okay, do you accept the friendly amendment?
So I'll accept the friendly motion, then it has to be seconded.
Second.
Other person.
Yes.
Okay.
We're good to go.
Okay, we're good. Okay, great. Okay. Ms. Cruz-Jones, can we do a roll call? Oh, shoot, the phone. Are there any comments on the phone?
Are there any comments on the phone?
I'm showing no comments at this time.
Thank you.
Dr. Bolat.
Aye.
Dr. Gonadev.
Aye.
Dr. Hawkins.
No.
Dr. Kraus.
Aye.
Ms. Lawson.
Aye.
Dr. Lewis.
Aye.
Ms. Sutton-Wills.
Yes.
Mr. Wormuth.
Aye.
Ms. Wright.
Yes.
Dr. Yip.
Aye.
Ms. Pines.
Aye. The motion moves.
All right. Okay, moving on to the next bill, AB 608. This bill would specify a medical assistant's technical supportive services, includes drawing up a local anesthetic such as lidocaine and a syringe if specifications are met. So the supervising licensed physician, podiatrist, physician assistant, or nurse practitioner has to be present when the medical assistant is drawing up the anesthetic. A supervising licensed local, the anesthetic has to be reconstituted by someone with a license to do so or come reconstituted from the manufacturer. And this bill includes an urgency clause which would take effect immediately upon signature. So existing law does not specify if a medical assistant can draw up a local anesthetic. However, it does prohibit a medical assistant from administering that local anesthetic. This bill would make it clear that drawing up an anesthetic is permissible to be included in the medical assistant's technical supportive services and specifies under what conditions. This has been a gray area that board staff agrees needs clarification. There's some, we've been getting calls from interested parties asking questions about this, and it's not really clear. Other than that they cannot administer it, and so this is their attempt basically to make it clear there's kind of a gray area that law and regulations don't cover, and so we, board staff in these meetings were basically like, well, if you want to make it clear, you should probably run a bill, and so this is the result of those conversations. So we're just suggesting that we take a neutral position on this bill.
Are there any questions or comments? Dr. Kraus.
I would actually like to move support if amended and speak to that. And my amendment would be in the wording of the bill on our page 6, at line 26, where it speaks of supervision, who shall be physically present in the treatment facility. One of the problems with being physically present in the treatment facility is you can be at the other side of the office. And I would like to have that changed, who shall physically observe. And the reason for this, I can understand the desire for the bill, because if a dermatologist is working on a Mohs procedure, which can be prolonged, and is working with sterile technique and needs more anesthetic, it's simpler for him to ask the medical assistant to draw up more anesthetic than to break scrub and do it himself, or to have his certified assistant break scrub and do it himself. But there have been cases where the wrong solution has been injected. The medical literature is filled, even with certified people, of case reports of formalin being injected instead of local anesthetic, of chlorhexidine being injected. So if the wrong material is drawn up, there's great risk of harm. And I can imagine a circumstance where you only require supervision on the premises, where there might be an office where a medical assistant is directed to draw up and have a syringe of local anesthetic available in every treatment room, and nobody's observed that. So I think that there is a need for this bill, but I think it needs to be changed to physical observation rather than on the premises. Even when I'm operating in the operating room and I ask for more local anesthetic, there are 2 certified personnel who witness that and verify the vial of anesthetic. So to simply authorize an MA to draw up local anesthetic without direct observation would be dangerous.
So instead, I just want to clarify just in case we take that. So instead of saying is present, it would be?
Well, in paragraph 3, where it defines supervision.
Oh, okay.
It says supervision means the supervision of procedures authorized by the following practitioners within the scope of their practices, who shall be physically present in the treatment facility. And I would change line 26 to 27 to read, who shall physically observe the performance of this procedure. So if a dermatologist is in the treatment room doing a procedure, his MA can show him the vial and witness it being drawn up, rather than being on the premises but not observing it.
Okay.
Ms. Webb?
Yeah, so I think we need to look at page 7, starting at line 20. It says this is one of the things that has to occur for them to be able to draw up a solution, and that is that a supervising licensed physician and surgeon, licensed podiatrist, licensed physician assistant, licensed nurse practitioner, or certified nurse midwife is present while the medical assistant is drawing up the anesthetic. Now, it still says present there, so if a change is gonna be requested, then it would have to go in that
Yeah.
section.
Because that's the section that's being changed.
That's fine, but
Okay.
being present doesn't mean that you're observing.
The scenario that they gave us is exactly the scenario that you're talking about, is they are assuming that that person is in the office working on the, just like you said, working on the person and having the MA just basically hand them. So, I mean, I don't think that they would, so instead of is present, it would just be observed.
Physically observe.
Dr. Lewis?
Yes, I looked at the analysis section, and I think all those points are in the analysis unless, Dr. Kraus, you can see one that is missing out of here. See, the analysis says President verifies each syringe label is accurate, and someone who has to reconstitute it must be licensed to do that. So you're saying in the body of the text it's missing?
I think the action of taking the vial of medication and drawing it up has to be physically observed by a certified person. And being present doesn't necessarily define physical observation. A supervising physician can be present and not be in the same room as the person being supervised.
So just one other point, a supervising licensed physician, podiatrist, PA, NP, verifies that each syringe label is accurate. You want to go beyond and actually state that, what, addition to that?
If you're not present during the drawing up of the medication, you know, you walk into the room and the syringe is labeled, you verify
pick
it's
up the wrong-
accurate, but you
yeah.
didn't witness the drawing up of the
Yeah,
medication.
okay, I understand.
Dr. Yip?
Dr. Kraus is right. The syringe can be labeled lidocaine, but the MA can go to different draw potassium, which is a disaster.
Put it down on the tray.
Right, they can just draw up. In the hospital setting, we actually very strict about even have labeled water and all that. But even that mistake happens, so I think it's a good thing that the physician should observe the actual drawing of the medicine.
Physician or other certified personnel.
Ms. Kirschmeyer is going to read it.
So I think what you're looking to change is on page 7, down at the bottom 7, or page 5 up at the top. It's under big C, little I, a supervising licensed physician and surgeon, licensed podiatrist, licensed physician assistant, licensed nurse practitioner, or certified nurse midwife is physically observes the medical assistant drawing up the anesthetic.
Yes.
That's what you're looking for. And that change would cover everything. So we can do support if amended.
Okay. Can I have a motion to,
So move.
a second?
Second.
Okay, great. Are there any comments from the audience? Any comments on the phone?
Are there any comments?
No callers in the queue.
Ms. Cruz-Jones, can we have a roll call?
Dr. Bolat?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills?
Abstain.
Mr. Wormuth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Aye.
Ms. Pines?
Aye. The motion carries.
Okay, next bill, AB 1751. This is the bill that would allow for information sharing between cures and other states' prescription drugs monitoring programs. So the board had a support position on the previous versions of this bill. Amendments were taken since our last board meeting to require DOJ to adopt regulations by July 1st, 2020 regarding the access and use of information within cures, and the regulation must address the specified information. This bill would require DOJ to consult with stakeholders representing law enforcement agencies, licensed prescriber and dispenser communities, and any other stakeholders identified during the rulemaking process. And staff doesn't have any concerns with this amendment, as this is something that is needed and should have already actually been done. The other change would allow a healthcare practitioner who is eligible for access to cures, or a pharmacist who is employed by a health insurer or a healthcare services plan and is involved in accepting, denying, or adjusting a claim for health insurance policy benefits or healthcare service plan contract benefits related to controlled substances, to access cures for purposes of reviewing a claim. Many stakeholders actually oppose the change that I just talked about, and staff does have concerns with practitioners checking cures for non-prescribing purposes, such as to grant or deny payment. So we have that one concern with one of the amendments, so I'd just like to open it up for the board discussion to hear if any other board members have concerns with that amendment being added.
Are they, Dr. Gananade?
Oh, simple answer is yes. It's a serious concern because it should be only for the prescribers or their staff, not for insurance company people and so on and so on.
So before we supported the bill, so I guess you have a couple options. If other members agree that this is a concern, we could either do a support if amended position because we supported it previously, or we could do oppose unless amended. Those are kind of our two options.
Dr. Bolat?
Yeah, I have a question, and maybe you can help me understand. I completely agree with Dr. Gananadev in his comment, but was the issue that the PBM, the Pharmacy Benefit Manager, Group Management Group, was going to be included? Because as you all know, the PBMs are sending us information all the time saying, hey, Dr. Bolat, did you know your patient's on ABC 123? And so that was my question. Was it the PBM? But it does open up a can of worms, and I do appreciate the whole issue. So
I'm not really sure why this was kind of a weird one because it got added in committee and no one really knew that this amendment was going in, and so people were fully supportive of everything else, and all of a sudden when it came out in print, there was this new amendment that no one knew about. So I'm not really sure how it got there, but the concerns, yes, I've heard the PBM concerns, but it's also a concern of even other healthcare practitioners just using it to for treatment decisions or denying certain medications based on the cure's history. And so, like I said, those are kind of our two options. Before we were really supportive of this bill, and I went up and testified every time, but now there's this amendment. It kind of puts us in a weird position. So we can, if we want to be really strong, we can do oppose unless amended, or if we want to take it more friendly, we could do support if amended.
Are there any other comments, discussions, questions?
There are a lot of good things in the bill. This is a bad thing.
Right.
So I think if you take support if amended and basically asking them to remove this amendment they added on.
Okay.
So do we have a motion?
I can make a motion support if amended.
Second?
Second.
Okay. Are there any comments from the public in the audience? Any on the phone?
No callers in the queue.
Okay, the motion moves. Ms. Cruz-Jones, please call roll.
Dr. Bolat.
Aye.
Dr. Ganadev.
Aye.
Dr. Hawkins.
Yes.
Dr. Kraus.
Yes.
Ms. Lawson.
Aye.
Dr. Lewis.
Aye.
Ms. Sutton-Wills.
Yes.
Mr. Warmoth.
Aye.
Ms. Wright.
Yes.
Dr. Yip.
Aye.
Ms. Pines.
Aye. The motion carries.
Okay, next bill, AB 1998. This is the bill that would require by July 1st, 2019, every healthcare practitioner who prescribes, orders, administers, or furnishes opioids to establish or adopt a safe opioid prescribing policy. The board previously had a neutral position on this bill. However, it's been amended since our last meeting. So now it would specify that a healthcare practitioner or group of practitioners is deemed to have satisfied the requirements by adopting a nationally or professionally recognized guideline or a guideline established by a state licensing board or commission that was updated after January 1st, 2015. It would also require, they would require every policy to include a requirement that a prescriber offer a prescription for naloxone, and that kind of goes along with other bills that the board was supported. AB 2760 requires that too, if specified conditions are met. And it would also now require Department of Public Health by July 1st, 2024 to submit a report to the legislature and publish the report using data from the Cures database detailing progress toward the end goal of continuing in a year-over-year downward trend for opioid prescriptions in California. So the amendment that basically says that you can use a guideline by a state board or commission that was updated after January 1st, 2015 was actually aimed at our guidelines because we established them in 2014. So that was a conscious amendment to try to incentivize us to update our guidelines. I explained to the author's office and committee staff that we can update our guidelines anytime if we get feedback that they need to be updated, that we have a process that we have to go through, that we have to take it to the board, and that we would really like physicians or groups to be able to use our guidelines in the meantime until they're updated again. So, because that amendment is in there, staff is suggesting that we do a neutral if amended position and ask that either it be changed to 2015 or that part about anything before 2015, or just take that part out because we would like physicians to be able to use our guidelines. And so that's what staff's suggesting, a neutral if amended position.
Are there any questions from members? Dr. Gananadev?
Just a comment. Dr. Bishop on this board did an extensive amount of work to come up with the guidelines. And I'm told at AMA meeting that our guidelines are better than CDC guidelines. I don't know what our state legislature is trying to do. It just mind boggles me.
Are there any other comments or questions? And do we have a motion? Can someone put forth the motion?
Yeah, just curious. A neutral if amended, that's an odd motion.
Well, so before we had a neutral, but so we want an amendment. So.
The reason we have a neutral position is this isn't really one that impacts the board. It's not something that's specific for us, although we're weaved into it now with the requirement for the 2014. And Ms. Simoes and I have talked about it, and we still have Ms. Lawson here, who was on our original prescribing task force. We've lost Dr. Bishop, but we can put our task force back together and go, if it does pass with the 2015 in it, we can go forward by the end of this year and look at what we need to do. I mean, we've talked about, we want to add more information about naloxone in our guidelines. We want to add more information about medication-assisted treatment in there. So we can make some changes to it and bring it back to the board for review, but we do believe that it should go back to 2014 when our guidelines were in place, because we still find them very helpful. So that's why we have a neutral if amended.
Move staff's recommendation.
Neutral if amended.
Okay. So we have a motion? Okay, a second we have? Okay. Are there any comments from the public?
Dr. Gananadev, did you second that?
Yeah.
Okay, thank you.
Even though it's an odd motion, but yes.
Any comments from the audience? Any comments on the phone?
No callers in the queue.
Okay. Ms. Cruz-Jones?
Dr. Bolat?
Aye.
Dr. Ganadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright?
Aye.
Dr. Yip?
Aye.
Ms. Pines?
Aye. The motion carries.
Okay, next bill, AB 2138. This is the bill that would limit the current discretion given to boards, bureaus, and committees within Department of Consumer Affairs to apply criminal conviction history for a license denial. This bill would prohibit regulatory boards from requiring an applicant to self-disclose criminal history information, and it would require boards to collect and publish demographic data regarding applicants who were denied licensure or who have licenses revoked or suspended, among other provisions. So the board previously strongly opposed this bill. It really limited our authority to deny licenses based on criminal convictions, to take enforcement actions based on criminal convictions. However, it was significantly amended in Senate BMP, and the amendments actually did address many of the board's concerns. However, this bill still does limit the board's current discretion to deny a license based on criminal convictions. Staff still has the following concerns. So it would not allow the board to consider the acts underlying the conviction for dismissed or expunged convictions. It would not require an applicant to disclose criminal conviction information on the application. It would not allow the board to automatically deny an application if the individual is a registered sex offender, as existing law allows. And lastly, this bill would not allow the board to include criminal convictions for crimes that have been rehabilitated, dismissed, or expunged as one of the reasons to deny a license. So staff is suggesting that the board now take an opposed unless amended position with requesting those amendments that I just went over, and we've actually relayed our concerns to interested parties that we still have these technical concerns. So
I make a motion to oppose unless amended.
Okay. Any questions from members, comments? Any questions from the audience? Comments? Any comments on the phone?
I'm showing no comments at this time.
Okay. Ms. Cruz-Jones, can we take a vote?
Dr. Bolat?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills?
No.
Mr. Warmoth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Aye.
And Ms. Pines?
Aye. The motion carries.
Okay, moving on to the next bill, AB 2193. This bill would require by July 1st, 2019, a licensed healthcare practitioner who provides prenatal or postpartum care for a patient to ensure that the mother is offered screening or is appropriately screened for maternal mental health conditions. This bill would also require health insurers and healthcare service plans to develop maternal mental health clinical case management programs as specified. So before, and the board actually took an opposed position on this bill. I don't know if you remember, there was a significant amount of discussion, and it actually required that a set number of screenings take place if any person saw the mother or the child in a certain time period. So now it's just basically saying that if you see the mother, that you just ensure the appropriate screening. It's not so much legislatively mandating the practice of medicine and law anymore. It's not like, okay, if you see, they have to have one screening before and one screening after, like the bill did before. So because it's, the amendments are pretty significant, board staff is now suggesting that the board take a neutral position on this bill before we were opposed.
Okay, do we have any comments or questions from board members? Can I have a motion to approve staff recommendation? Dr. A second? Do I have a second?
Second.
Okay. Are there any comments from the public? Dr. Reed?
Yes, thank you. I would encourage the board to consider the ramifications of remaining neutral on this issue. Certainly in certain patient populations, especially in the African American community, there are several initiatives that are ongoing in nonprofits in the Inglewood area that support new mommies. And so supporting this measure would certainly make a statement and show that we're moving in the right direction as far as recognizing minority health. Thank you.
Thank you. Are there any additional comments in the audience? Are there any comments on the phone?
I'm showing no comments at this time.
Okay. Ms. Cruz-Jones?
Dr. Bolot?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills? Mr. Warmoth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Yes.
Ms. Pines?
Aye. The motion carries.
Okay, so the next bill, AB 2487, you may remember this one from last time. We had a significant amount of discussion. We actually didn't come up with a position. This is the continuing medical education bill, and it was regarding buprenorphine. So this bill was also significantly amended. So now it would allow physicians the option of taking the currently required one-time 12-hour continuing medical education course on pain management, or they could take a one-time 12-hour CME course on the treatment and management of opiate-dependent patients, including 8 hours of training in buprenorphine treatment for opioid use disorders. So instead of a new CME requirement, it's taking the existing CME requirement and saying physicians, you can either take that one-time CME in pain management, or you can take it on this, you have an option of doing pain management, or now you have this option of opiate kind of CME training, with a portion of it being buprenorphine. So it's not a new CME, it's just allowing physicians the option of, when they fulfill that CME requirement, that now they can take this other course. So with that amendment, board staff is suggesting that we just take a neutral position on the bill. So open it up.
Second.
Great. Are there any comments from the members? Or any comments from the audience? Any comments on the phone?
I'm showing no comments at this time.
Ms. Cruz-Jones, can we have a vote?
Dr. Bolot?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Yes.
Ms. Pines?
Yes, the motion carries.
Okay, so moving on, AB 2789. This is the e-prescribing bill that we actually took a supportive amended position on last time. So this would require all prescriptions issued by licensed prescribers on or after January 1st, 2022 to be issued as e-prescriptions. And there are specifications in the bill that we went over last time. So at the last meeting, like I said, we supported requiring e-prescriptions, but the board members did raise some concerns that some prescribers in rural areas may not have access to the technology needed to issue e-prescriptions. The recent amendments do delay the implementation to 2022, which will allow physicians in rural areas more time to comply with this bill. So our options are the board can continue to take a supportive amended position, or it can change its position to support based on the further delay in implementation, which would allow rural areas more time to have the e-prescriptions. Just as an aside, we're kind of the only ones that have brought up the rural area issue. So when I go to hearings, we're the only ones that are bringing this up. And Wood's argument is that he's the author of this bill, that he's in a rural area and he understands about rural areas, but he thinks 2022 is basically ample time for rural areas. So I'm just bringing it to you again. They did delay the implementation date by another year to address some of these concerns. So we can, like I said, we can continue to take a supportive amended, or we can move it to support because they did delay implementation a little bit.
Okay, Dr. Lewis?
I'm just a little worried that, again, this bill will cause the rural area physician some undue hardship, because to do e-prescriptions, as I haven't done a little bit, there's an electronic system that generates them to send them to a receiving pharmacy, correct? So you have to have either an electronic health record system that captures that and has the formula in it. So then it requires the rural physician to obtain all that extra electronic equipment, which is not inexpensive. So I understand the spirit of it because it's a protected prescription. It's encrypted as it goes along its way. I just wish there was another way that these rural physicians could not be unduly burdened. I'm just throwing it out there. Thank you.
Any other comments, Dr. Kraus?
I e-prescribe. About once a week, a patient refuses to have me e-prescribe. And most often they say, I don't know which pharmacy I'm going to bring this to, and I give them a written prescription. I don't see that as a exception in this law that would allow a patient to refuse an e-prescription.
Dr. Kraus, would not section subdivision E48, sub 8, it's on page AB 2789-7, line 35. It's in the exemptions section. So this requirement does not apply to any of the following. The prescription is issued by a prescribing healthcare practitioner under circumstances whereby the practitioner reasonably determines that it would be impractical for the patient to obtain substances prescribed by an electronic data prescription in a timely manner, and the delay would adversely impact the patient's condition.
I suppose it can be interpreted to include that circumstance. Thank you.
Dr. Gananadeb?
Yeah, I understand the rural areas. I do see the difficulties there, but it has shown multiple times that prescribing cuts down the errors, makes a significant difference in medication-related adverse reactions, because it tells you that if you need electronic health records when somebody else is on that some other medication, if there is a drug interaction. So I think it's time for us to go there. I know we're still struggling, but it's about 2 years from now, so.
Really 3 years. About 3 years. Is it
2022.
2022? Okay.
Has to be fully implemented 2022.
2022. They delayed it a little further to take care of some of the concerns, so.
Okay. So are there any other? Can I get a motion, or do we have a motion to support?
Move to support.
Okay. Second. Okay. Are there any comments from the public in the audience? Any on the phone?
I'm showing no comments at this time.
Okay, Mr. Cruz-Jones, roll call.
Dr. Bolat?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright?
Aye.
Dr. Yip?
Aye.
Ms. Pines?
Aye, the motion carries.
Okay, the next bill, SB 944, and we did kind of remember Dr. Backer's presentation yesterday on community paramedicine. It's somewhat related to this bill. So SB 944 is the bill that would create the Community Paramedicine Act of 2018 and would authorize a local emergency medical services agency to elect to develop a community paramedicine program to provide specified community paramedicine services until January 1st, 2025. So before the board had an opposed position, but there's been a lot of amendments actually taken to this bill to add more layers of oversight, and it actually now has a sunset date in it, which it didn't have before. So it would sunset on January 1st, 2025 unless more legislation is introduced. So now it also, some of the added layers of oversight would specify that if a local EMS agency elects to develop a community paramedicine program, the County Board of Supervisors would be required to establish an emergency medical care committee with specified members, including 2 emergency room physicians, to advise the local EMS agency on the development of the community paramedicine program. This bill would also now require IMSA, or Emergency Medical Services Authority, to develop and adopt minimum medical protocols after they are approved by the Community Paramedicine Oversight Committee for each community paramedicine program. It would require the protocols to be based upon and informed by the formation and implementation of the Community Paramedicine Pilot Program, and that's the program that Dr. Backer was talking about yesterday that's been in existence under Health Workforce Pilot Project. And further requirements provided by local EMS agencies during the course and operation of that pilot program. This bill would also now specify that if a community paramedicine program elects to provide services to treat hospice patients in their home or provide patients with transport to an alternate destination facility, the community paramedicine program must meet additional requirements, including developing triage protocols, certifying that the alternate destination facility has adequate medical staff, facilities, and equipment, and develop specific protocols for alternate destination transport. So we had an opposed position before, but like I said, these amendments add more layers and more requirements for protocols and triage protocols. So our options are we can continue to oppose the bill, or in light of the added oversight and newly established sunset date, the board could change its position to neutral. But that's entirely up to you, and you can also kind of remember the stuff that Dr. Backer, when you're making your decision on what position, kind of what's happened so far and what the results have been. And there continues to be in here, if you go through the analysis, requirements for a study, requirements for IMSA to continually monitor it. If there's any adverse outcomes, they can elect to just basically revoke the community paramedicine program. So there's a lot of oversight at the local level, at the state level. So that's kind of the 2 options. We can continue to oppose, or we can go more neutral.
Dr. Kraus?
Like many members of the board, I was in opposition to paramedicine in its first formulation. And I think our opposition was effective. I think that we've been listened to, and that many modifications have been made to appease us. And I think that I've personally been convinced that under these circumstances, it's a safe program, and I would move to take a neutral position.
I second that motion.
Do we have any comments or questions from members? Dr. Bolat?
Yes, I think I mentioned it yesterday. There is one concern, and that is on page, let me see, I'll scroll down here, on SB 944, page 2. The bullet that I'm the most concerned about, I'm not at all concerned about DOT, or directly observed therapy. I think that's a great thing. Case management services for the frequent flyer. The hospice, to be working closely with a hospice nurse and hospice agency. And I think the sticking point for me is this discharge for very ill patients. And I think that is my concern, because every hospital system is looking at reducing its 30-day unplanned readmission, and those very patients that we do know that go home or go to a home health agency, but go home as opposed to a SNF, come back within 7 days of their discharge. So it means that somewhere along the line, these are really sick patients. Now, whether the discharge was premature or whatever it is, my concern is there's a lot going on when you're taking care of a CHF patient, a patient that has pneumonia. So you're doing a lot of medical assessment. So that is my concern on this. So that's, but I'm certainly in support of the other bullets. So that's just my comments.
Any other comments, Dr. Ganavande?
Yeah, there are a few good things, but there are still some significantly concerning things in the bill, so I think neutral is fine.
All right, so we have a neutral. Are there any questions in the audience? Dr. Ree?
Yes, hello. I would also agree that this is a wonderful piece of legislation, and I'm so glad I was here to hear about this. That certainly, for myself, being a member of the American Academy of Home Care Medicine, where I believe it was 2011, CMS approved increased reimbursements for house call visits. So that's very exciting to be a part of that and to see this here, because it's going to be very helpful to the inner city populations, places like, of course, Compton, Oak Park, and several others. So for community members, sometimes I often hear, I don't want to go to the ER, I don't want to go, or they always end up going there and not needing to. So there's all, both extremes that I've seen. And so this is really great that, these paramedicals are probably part of the community. I've heard from patients say, yes, I had to call the fire department and come pick me up. I fell, I couldn't get up. And it was the same guys, and they said it's always helpful that they're good looking too. So they're welcomed into the home and certainly welcome to treatment. That's great.
Thank you. Are there any additional comments in the audience? Any comments on the phone?
We're showing no comments at this time.
Okay.
Dr. Bolat?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton-Wills? Mr. Warmoth?
Aye.
Ms. Wright?
Aye.
Dr. Yip?
Aye.
Ms. Pines?
Aye. The motion carries.
All right, next bill, SB 1238, is the bill that would require healthcare providers and group practices to notify their patients using the patient's last known contact information before the patient's medical records are destroyed. If you remember from last time, the board took a support and concept position at this bill on our last board meeting. The board supported the concept of this bill. However, the board did have some concerns with holding physicians liable for patient records not in their control. The author's office has been working with us. I've been meeting with the author's office on a regular basis, and they did take amendments to require group practices and clinics that are the custodian of the patient records to be responsible for complying with the requirements of this bill instead of the individual providers. And these amendments are intended to address the board's concerns. However, it's still unclear who would enforce the bill's requirements for group practices and clinics that are not licensed by CDPH. The board could not really enforce these requirements since it does not have oversight over these entities. In addition, this bill would not require clinics licensed by CDPH to comply with the requirements of this bill. So they did kind of a weird thing. They said, okay, if you're in a group practice or a clinic, that group practice or clinic, if they have the records, they're required to comply. But then they said, but facilities licensed by CDPH are exempted. So then they really don't have to comply. So it was a weird amendment that they took, but the author's office has been working with interested parties and Assembly Health on amendments. So with the bill, it's unfortunate that we meet right now because they're on break, and then they're going to come back, and this bill's going to get amended, and we're not going to have really another opportunity to take a position. Right now, my suggestion is really that we do a support if amended and ask for some amendments regarding the oversight, who has oversight of the clinics and the group practices. And the fact that all clinics are exempted from the bill basically means that anyone who's seen in any facility licensed by CDPH isn't covered by this bill. But in the meeting I was at with Assemblymember Wood and Senator Roth and some interested parties, Assemblymember Wood had the idea of actually putting a 10-year retention requirement for all across the board for anyone, and then also requiring the notice. One of the concerns by opposition is that in notice, it's like basically I'm about to destroy your records and I have to send out a notice, and I think some of the board members had concerns with that as well. And his idea is actually to require a form up front that would basically say, the patient would opt in, I want to get my records before they're destroyed, and this is how I want to get notification, by email, by a mail, whatever it might be, by a telephone call, and that would be done at the beginning, and so it would be like an opt-in kind of thing. So those are the amendments that they're kind of discussing right now, but the bill in its current form is what we have in front of us, and so I kind of open it up to discussion, but the problematic areas that we see with the bill in its current form is that it exempts every facility licensed by CDPH, and then who's going to actually have the oversight over group practices and clinics that are not licensed by CDPH. So those are the two concerns. They're willing to work with us. They've been really willing to take amendments and address the board's concerns. They actually watched our board meeting discussion at the last board meeting to try to really get to the heart of what the board had concerns about. So they're really invested in this bill, which is why I would kind of like to take a more positive position, like a support if amended, since we supported the concept before, but I'll put it out to the board for discussion.
Dr. Lewis?
I move, we already did it. I'll second it.
Okay. Dr. Gananade?
I'm glad Senator Roth didn't call me if you watched the discussion last time. You pointed out, Jennifer, the real concern. I think, first of all, who is going to be in charge? What to do? I mean, if it is doctor's offices, it has to be medical board. If it is CDPH, licensed clinic, it has to be CDPH. And it makes no sense that we use this on one end, but not on the other thing, where the practice is actually divided between multiple entities. So all the concerns you brought up are the same ones. I just want to make sure that you stick with all of the ones you brought up for us that support to go.
To echo and amplify, it's an unfunded mandate that increases the cost of delivery of health care, more burdensome to solo and small group practitioners. And if indeed we wish to establish a right of access to records, it really should be applied uniformly to all healthcare records, including hospitals and clinics, and not just licensed physicians.
Dr. Lewis?
And to echo onto that, it is going to increase the cost. It is going to increase the cost of health care, because how can you ensure that these records were delivered? Does that require an extra level of notification? Who keeps up with their change of address? I mean, there's a lot of things that are going to make it costly for that solo practitioner, maybe not for some huge groups, but even them. So I'm just making sure you stick with those concerns when you talk to Senator Roth and others, and Senator Hill and those people. Thank you.
Dr. Bolat?
Yes, thank you very much, Jen. Couple of questions. In the analysis, is it clear that it's 10 years for any age patient, or 10 years for adult patients, and then age of majority plus 7 for pediatric patients? Does it specify?
No, so right now that amendment's not in there. That's what they've been talking about, and when they come back in August 6th, probably the amendment will go in there. That's just kind of, I was just kind of trying to update you on the discussions on where it's going now, but right now there is no, it basically says the physician has to inform the patient of their retention schedule, and then offer that before they're destroyed, offer that notification to the patient so their records are going to be destroyed. But honestly, the 10-year retention would be a really good thing, because right now there's not a blanket retention period requirement, but it's not in the bill. Unfortunately, it's not in the bill right now.
I see. And then the other point to that is that what you said about the upfront, so that this is another reason why electronic health records are important, because the after-visit summaries actually summarize nicely, if they're set up well, what were you in for, what is your education on the particular condition that you're having. So I would think that having people understand up front that there is going to be a limitation and that it really is incumbent upon that healthcare consumer to say, hey, I would like my records. And believe me, healthcare consumers do ask for them very often. They know that at the end of their visit or within a few days, they can get that up to 15 pages. In most places, they do all of this gratis, but the storage of medical records is extremely expensive, and I would concur that there should not be a two-tier system, whether it's CDPH or a physician's office.
Dr. Yip?
I think the intent is good, but when you have to discuss with legislature, what I'd like to do is actually encourage a format that actually provide information up front, first visit, second visit, or within a certain day. The healthcare environment is changing. In my community, one IP is actually developing a mobile cell phone app that actually the member of the IP can actually download information right at the visit and actually carry on to the next visit. I think that's the future. Most of my experience that people ask for record 2 years later, 7 years is for like life insurance or workers' comp case, not necessarily their own medical issue that they carry on to the other provider. So that kind of defeats the purpose. But I think we should encourage the pharmacy to be really upfront to provide information, have the patient carry their own medical record for the next 15, 20 years. So.
Any other comments? Any comments from the audience? Any comments on the phone?
I'm showing no comments at this time.
Okay. Ms. Cruz-Jones?
Dr. Bolat?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills? Mr. Wormuth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Aye.
Ms. Pines?
Aye. The motion carries.
All right, last bill. Patient notification, SB 1448. So you probably remember from last time we took a supportive amended position on this bill, and we asked that basically the same, that patient notification be required for the same categories that were required when that language was in SB 798. So basically the categories before that we, let's see, I'm just going to kind of skip over here. So what we had actually requested is, sorry. So what we had requested was basically that sexual abuse or misconduct, drug or alcohol abuse resulting in harm to patients, criminal convictions involving harm, and then if they'd ever been disciplined before, and any other case basically that the board thought should require patient notification. So we had many, many meetings on this subject with the governor's office, with interested parties, and we basically came up with some categories. They're very similar. They narrow them down, but they're not exactly what the board requested. So instead of the category of prior discipline in any case that the board thought should require patient notification, instead what the basically the kind of thing that we all negotiated was inappropriate prescribing resulting in harm to patients and a probationary period of 5 years or more. So if it was one of those cases, it would be probation notification. And the sexual misconduct definition changed a little bit. So now it reads a commission of any act of sexual abuse, misconduct, or relations with a patient or client, including but not limited to any of the acts described in Business and Professions Code Section 726 or 729. Drug or alcohol abuse directly resulting in harm to patients or the extent that such use impairs the ability of the licensee to practice safely. Criminal conviction involving harm to the patient's safety or health, and inappropriate prescribing resulting in harm to patients, like I said, in a probationary period of 5 years or more. So we did a little bit of changes here too. So it would be for a final adjudication by the board following an administrative hearing or admitted findings or prima facie showing in a stipulated settlement of any of those kind of cases, or an accusation or statement of issues allege that the licensee committed any of the above acts, and a stipulated settlement based on a nolo, contender, or other similar compromise that does not include any prima facie showing or admission of guilt or fact, but doesn't include an express acknowledgement that the disclosure requirements would serve to protect the public interest. And that, what I just read right there, is basically to get at the concerns raised by opposition where, they didn't basically admit to any of the findings. They pled nolo, but they didn't want probation notification to be based on the accusation. So, and Carrie can explain this a little bit more, but basically we had Carrie and other attorneys work on this language. So this basically, they're not admitting anything, but if they were to stipulate, we would make sure that that disclosure was in there. Carrie, do you want to add?
Just they're given notice that a stipulation for accusation charging these items will include the patient notification requirement.
So this is the closest we've ever been to all parties actually agreeing on something. That we have one outstanding thing where there's a concern by one interested party, which is the criminal conviction. So our board actually did approve criminal conviction involving harm to patient safety or health. And the concern is some of the interested parties believe it should be felony conviction, but that is the only thing that's outstanding. Everything else is agreed to upon by everyone. So I know in our last position, one of our amendments that we wanted was to require other boards, not just the medical board and the boards listed in this bill, to do patient notification. We have in our meetings with interested parties in the governor's office, we did bring that up. It doesn't sound like that's going to happen. It's going to be the bills that the boards that are named in this bill and us. So, it's up to the board. Like I said, this is the closest I think we're going to get to like everyone agreeing on this language, and it actually does do what the board asks. It narrows it down to, I think, some pretty good categories that are egregious. So I'm going to leave it to the board for discussion, but I think we're very close, and it's taken a lot of work to get this far. So open it up for discussion by the board.
Okay, Dr. Kraus, and then Dr. Hawkins.
Thank you for your hard work. I'd like to remind the board that I think for most of us, our only objections to patient notification has been a fear that we would be unable to serve the public adequately if respondents are refusing to agree to stipulation. And if we have to take every case to revocation, we won't be able to adequately evaluate every complaint and evaluate every case, and greater harm may be done. So to narrow the scope of it allays my fear to some degree and provides some protection to the public. Could you share with us what the experience has been in other states in the process of their boards in dealing with patient notifications?
I'm not sure that it's required by other states. I know we did a little bit of research.
Yeah, we did some research. I don't believe there's any state that requires that patient notification that we know of, though. That's just in our research. And
So we will be the first experiment.
We will.
Dr. Hawkins?
Could you remind us again about notification? Does it involve a phone conversation, signing something the person arrives? The details that a little bit more about what notification actually entails. You've told us which categories of.
Sure, I can tell. So it requires a licensee on probation pursuant to a probationary order made on or after July 1st, 2019, before a patient's first visit following the probationary order, to provide the patient or the patient's guardian or healthcare surrogate with a separate disclosure. And so it just has to be signed. So it's a signed, basically, piece of paper, I guess, a disclosure that provides information, basically directs them to our website to get more information.
Dr. Gananadev?
Jennifer Kim, I think you've done so much work on this one, so I know I was with you. Only thing which concerns me is that politics work here, and it's only to the boards which are in there, and it exempts a lot of healthcare providers. That's what concerns me, because a doctor spends 5 to 10 minutes a day with a patient, A nurse spends 8 hours a day. So these are the concerns I have. So other than that, I think we spent a lot of time on this issue. So I'm okay with what's in there, but I'm just unhappy that it doesn't include the others.
Any additional comments, Dr. Yip?
I think the intent is good, just need some clarification that the bill specifies licenses and employees is not required to provide disclosure of any of the following apply. One is that the licensee does not have a direct treatment relationship with the patient. I'm not sure exactly what it means.
Yeah, so that means like if the example that we kind of use, so like if you're going to the hospital and it's the anesthesiologist that you didn't know ahead of the appointment, or you go to the emergency room, there's a radiologist that you never see that takes your x-rays. That's kind of what it was meant to. Someone that you've never seen before, you wouldn't even know who it was for them to provide that notification before your first visit. That's kind of can you think of any more examples, Kim? Am I missing anything?
That's pretty much it,
Yeah.
what we talked about in coverage.
Pathologist.
True, pathologist,
Thank
right,
you.
right, yeah.
Because I was reading the licensee who will be treating the patient during the visit is not known to the patient until immediately prior to start. That I guess most is applied to inpatient.
Right, they're just trying to kind of they're trying to address some of the concerns, scenarios that the opposition brought up on why patient notification wouldn't be plausible, and so they provided exemptions to address a lot of those concerns. And what they really want patient notification for, that's your doctor, and they go on probation, and it's for one of those reasons that they provide that notification.
I just wonder how the hospital authority, California hospital is think that the doctor go in, the patient later was accused the hospital. You didn't tell me the doctor's on probation. They come to see me yesterday. So.
Well, if it falls under one of these exemptions, they wouldn't be required to, so.
And any complaint we'd
Yeah.
look into
Right.
if we got that complaint.
Thank you.
Okay. Any other comments? No. Okay. I have a slip here. Sorry. Okay. Second?
Second.
Great. Megan Allred?
Good morning, Megan Allred on behalf of the California Medical Association. Jennifer's right, this is the closest that we have been on this bill in many years. There are a couple of things to address some of the concerns and some of what she talked about. With the felony convictions, we have actually given language that we hope will be accepted in a compromise to include some of the wobbler misdemeanors against a person. So there's some specific language that we think will address that and take care of it. We would ask for support in them addressing that, and then also in the sexual misconduct language, just one tweak. But we would just also note that the board's app probably will do far more on this front than the bills, so we do appreciate that, since the notice will then come before the patient is finally in the office with the doctor. And otherwise, just wanted to make those few points and just ask for your support in getting the rest of that handled so we can get this bill done.
Thank you. Any other comments from the audience? Ms. D'Angelo?
Thank you. Julie D'Angelo Felmuth from the Center for Public Interest Law. We continue to support this bill, even though, in our view, it's the opposite of what Dr. Galan-Dev said. It's been narrowed down. But Jennifer's right. It's the closest you're going to get to to the position that you took last time. And I'm pretty sure I've done lots of legislation across the board that applies to all DCA boards or all DCA healthcare boards. And all you do by doing that is draw out all those other trade associations like the California Dental Association, California Nurses Association. Makes it much harder to deal with. So I think the bill is as close as we're going to get. And once the medical board does it, I think everybody's going to see that life as we know it is not going to end, and it will be applied to other boards. Mm-hmm. Thank you.
Thank you. Are there any other comments in the audience? Any comments on the phone?
Yes, the first is from Marian Hollingsworth. Your line is now open.
Yes, thank you. This is Marianne Hollingsworth from the Patient Safety Action Network. I'm glad the board has finally come around to supporting a bill to require doctors on probation to tell their patients. However, it is a very watered-down bill. For example, if a doctor has several DUIs, that, from my understanding, will not be told to patients if no patient harm occurred during that. I've also been told by Executive Director Kimberly Kirchmeier that the board can make exceptions in any case. Therefore, I would urge the board to include notification requirements to protect patients in cases where the doctor has multiple DUIs or addiction incidents that doesn't include patient harm. I would think the patient should have the right to know. You have done this in specific cases before SB 1448, so I encourage you to be even more vigilant if 1448 is signed into law. Finally, I would also like to take offense with Dr. Krause's comment that SB 1448 is an experiment. The issue of protecting the public should never be referred to in a frivolous manner. It shows the board is still more interested in protecting doctors rather than patients. Thank you for your time.
Thank you. Any other comments on the phone?
Yes, the next one is from Eric Andrus. Your line is now open.
Hi, it's Eric. Who are the interested parties you met with? Because as patient safety advocates whose specialty has been sex offending doctors, we weren't notified to give our opinions. Was the CMA contacted to participate as an interested party, an organization that 2/3 of the state's doctors refused to join? You need to remember that when considering any point of view they have. If they can't get 2/3 of the state's doctors to join their club, something must be wrong. Howard, you're concerned about how this bill will affect what doctors stipulate to, but you're not concerned about that the board is bartering away egregious harm and death charges so that they can give public reprimands instead, like in the case of the death of Tim and Tammy Smick's son that Ronald Lewis signed off on? I think you need to consider all of the problems with the board, not just this. Thanks.
Thank you. Are there any additional comments on the phone?
I'm showing no further comments at this time.
Okay, great. Ms. Cruz-Jones?
Dr. Bolat?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton-Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Yes.
Ms. Pines?
Yes, the motion carries. Our next item is 19B, status of regulatory actions. Ms. Simons?
So the matrix is in your board packets on tab 19, and I'm just really here to answer any questions you have on the status of the regulations on the matrix.
Are there any comments or questions from the members? Any questions, comments from the audience? Any on the phone?
I'm showing no comments at this time.
Okay, thank you, Ms. Simons. Okay, we're going to skip for a second. We're going to move to agenda item 23, which is discussion and possible action on approval of Mexico Pilot Program Orientation Program. Dr. Service, Ms. Alameda, and Ms. Webb. Hi.
Good morning. If you could please turn to agenda item number 23 in your packet. The licensed physician from Mexico pilot program was created to allow up to 30 licensed physicians specializing in family practice, internal medicine, pediatrics, and OBGYN from Mexico to practice medicine in California for a period of 3 years. Each physician selected for this program must complete a 6-month orientation program on the California healthcare delivery system approved by the board prior to leaving Mexico. This program was put into legislation in 2003. However, it requires funding by nonprofit entities in order to implement the program. The board has received a partial payment for the program and has assisted interested parties in beginning the process to implement this program. The board is required to approve the orientation program for this pilot program prior to the individuals taking this course.
I'm sorry. We have to stop. We've lost quorum and it's an action item.
people left?
I think maybe that's an indication we need a short break.
3, oh, 4 people left? Okay,
We should take a short break then.
okay. We're going to take a short break. 5 minutes, please.
Okay,
We're resuming.
I'll try this again. Are we on?
Hello?
Can you hear me?
Hello? Testing.
Is it on?
We're resuming.
Okay. The Licensed Physicians from Mexico pilot program was created to allow up to 30 licensed physicians specializing in family practice, internal medicine, pediatrics, and OB/GYN from Mexico to practice medicine in California for a period of 3 years. Each physician selected for this program must complete a 6-month orientation program on the California healthcare delivery system approved by the board prior to leaving Mexico. This program was put into legislation in 2003. However, it requires funding by nonprofit entities in order to implement the program. The board has received a partial payment for the program and has assisted interested parties in beginning the process to implement the program. The board is required to approve the orientation program for this pilot program prior to the individuals taking this course. Board staff conducted the initial review of the licensed physicians from Mexico pilot program orientation course curriculum and then requested board licensing consultant Dr. Mark Service to review and provide the board with his findings. Dr. Service is Vice Dean for Medical Education at the UC Davis School of Medicine, with responsibility for all undergraduate, graduate, and continuing medical education. He is also a professor of clinical psychiatry and vice chair for education in the Department of Psychiatry and Behavioral Sciences. Dr. Service continues to stay clinically active, seeing children and adolescents on the psychiatric consultant service at UC Davis and the Shriner Hospital for Children. Dr. Service's report is on page 23, 3 through 9. His initial report was sent to the individuals implementing this program. Upon their review, they submitted additional information to the board, which was also reviewed by Dr. Service. He has submitted an addendum to this report. Dr. Service is right here next to me to talk about the report and his findings.
Thank you. So, as stated, this is a curriculum that's intended to orient primary care physicians to healthcare delivery in California, and particularly in the setting of community health centers, FQHCs. So my review really was looking at the question of orientation to practice settings in California for competent primary care clinicians. So it's based on that assumption. My review of the initial materials that were provided, which are formatted largely as PowerPoint presentations in a kind of maintenance of certification style. There were 7 modules, each module containing multiple sections, as many as 8 or 9 sections in some of the modules. And they all had learning objectives, and they also did have self-assessment components. But in my initial review, I was concerned about the nature of the learning objectives, and that they were primarily recall sorts of learning, which really falls short, I think, of what we would typically think an advanced learner should do in terms of learning, which is application, synthesis, evaluation, in Bloom's orders of taxonomy that we use in education. So I did, in my initial report, recommend those changes to the objectives. And then also the use of self-assessment questions that would really evaluate learning at that higher level of learning, rather than simply recall sorts of questions. And then I did also think that there was one content area in orienting to community health center practice in the state that was under-addressed. There was only a very brief mention of the CDC guidelines around opioid prescribing, and there were sections on the differences in pharmacies and pharmacologic abbreviations, etc., orienting Mexican physicians to the practice of prescribing in the state. But I didn't feel that given the opioid epidemic and the severity of that issue, that was adequately addressed. And then there were a few mistakes in the content that I also mentioned in my initial finding. So I did receive back a actually comprehensively modified curriculum responding point by point to each of my findings and making significant modifications. And I thought that their response in terms of improving the learning and assessment elements of the content did adequately address my concerns about that. So I'm happy to take questions and make any comments that you would like.
Are there any questions from the members? Dr. Bolat?
Hi, Dr. Service. Thank you very much. You said a couple of words, maintenance of certification, and when I was hearing this originally on this program, my question is, and probably not into your purview necessarily, but the maintenance of certification that we all have to do through our specialty boards, when you say those questions were similar to maintenance of certification, can you elaborate exactly what you mean?
Well, simply that the modules themselves, I think, were organized using an MOC format, not necessarily the level of questioning. None of this really relates to medical knowledge or patient care per se.
Thank you.
It's orientation to healthcare delivery in the state, the differences between practicing in California compared to another country. And so most of the content focused on systems-based practice competencies, differences in healthcare delivery systems and how one practices in an FQHC setting, but not the actual clinical practice that we think of with patient care and medical knowledge. As well, there was a section on professionalism and ethics, I think, to ensure that any differences that there might be around perceptions of professionalism and ethics between one state and a foreign country were addressed.
Thank you.
Any other members? Okay, I have a couple of slips here. Dr. Cuveras?
Did the members want to make a motion?
Can I get a motion to accept?
I so move to accept recommendation.
A second? Okay, thank you. Please begin.
Thank you and good morning.
Good morning.
I'm Dr. Max Cuevas. I'm Chief Executive Officer of Clínica de Salud Valle Salinas, a network of community health centers, federally qualified health centers in Monterey County. I'm a board-certified obstetrician gynecologist, seeing some of our patients in the clinic system, and I'm currently the president of the Monterey County Medical Society. And first of all, I'm really grateful to Dr. Service, get to meet him. We were involved in putting together the curriculum, and when we saw the wonderful comments and descriptors that were put in to improve this curriculum, we were excited and quickly jumped on it to make this curriculum fit the academic model that we were looking for. Our program came into being in response to widespread need for more physicians in particularly agricultural producing areas of California. The community health centers that are going to be participating in this pilot are basically from the Central Valley of California, the San Joaquin Valley, out in Tulare County. And then we've got 3 other health centers, fairly large ones on the central coast of California, down in Ventura, ours in Monterey County, and then in neighboring San Benito County. So we'll be bringing in 30 physicians, and the idea being that, again, we could utilize the primary care source of doctors as a model to respond to the massive need for physicians that can serve a population in a specific language and with specific, serving specific cultural needs. We're setting it up and looking at it as a study, both formative and then at the end, to make sure that this study or the pilot is able to deliver on not only access to care, but we're looking at the quality. All of the health centers that are participating are all Joint Commission accredited or NCQA accredited for quality. The physicians will be monitored using the same monitoring that we use for our regularly licensed physicians in California. Every physician develops a physician profile, and we will look at that, and we'll be working with the evaluators from both UC Davis and from the National Autonomous University in Mexico City that is looking at this. The Mexican government from the very beginning became interested in not only looking at it as a pilot to deliver healthcare services, but looking at it as a pilot with international politics as the focus.
Please conclude.
A lot of people come in to California that are here working, and this would be a way to provide services to them as well.
Thank you. I have another slip here. Arnaldo Torres. Is that you?
Yes, I'm Arnoldo Torres, and I and Dr. Cuevas wrote this legislation 17 years ago. The reason why we had the difficulty in getting it to this point is because no medical school in the state of California, there weren't any private as we now see, but none of the UC schools, USC or Loma Linda at the time, wanted to do the orientation. And the orientation, the medical schools had a second bite at the apple of saying no to this program. The medical board opposed the bill at that time, despite us taking and inviting all of the medical board to go. We had Ron Joseph send 2 or 3 people at the time to go to Mexico to see all of the things that are being done there. But I did want to bring to your attention very specifically, the requirement is that a doctor be licensed, certified, or recertified in good standing in their medical specialty in Mexico. This certification or recertification shall be performed as appropriate by the different colleges that Mexico follows, just like you follow here in the United States. They would have to pass the board review course in Mexico with a score equivalent to that registered by U.S. applicants when passing the board review course for the United States. So the passing board standard in the United States is 80. It's the same in Mexico. We had the representatives of UNAM come to the board a year and a half ago in May, along with representatives from each of the colleges of the 4 disciplines that we have coming. They made the presentation on their analysis, the comparative analysis of the 2 systems for board certification in the United States and Mexico. And the board staff recognized that we had in fact met that requirement. The other requirement, because there was some very, very surprising comments from some people in other parts of the state, that this somehow is going to be hurting the diversity issues and that some people that don't speak or that speak English will not be understood by these doctors. There's a requirement that they would have to be enrolled in an English as a second language class that focuses on both verbal and written subject matter. Each physician participating in the program shall have transcripts sent to the medical board from the appropriate Mexican university showing enrollment and satisfactory completion of these classes. They are also required to continue to take those classes while they're here in the United States. We would tell you that of the 30 that have been selected, at least 10 are already completely fluent. They score over 90 on the TOEFL exam. So they are they are considered English speakers. So we understand that there will be populations in our clinics that do not speak Spanish. So we kept the English requirement. This program will be done in English. So any concern or any idea that these doctors will not be able to communicate in English could not be further from the truth. The other thing that we would point out to you is that these doctors also will have to go through a 6-month externship, probably anywhere from 4 to 6 months after they arrive. There will be an evaluation program that will be done. UC Davis's medical school has already indicated an interest to do that. They've spoken to the medical board staff about that. And then there'll be a third review, and that'll be done either by JACO, NCQA, or the HMOs. So there is no standards that these doctors will be going through or having to meet that any doctor in the state of California has to meet in a 3-year cycle. So these doctors are going to be reviewed very, very thoroughly on a continued basis. So we just wanted to make sure that you understood that. And the last thing, and then I'll stop, but I want to make sure that everybody is very well aware of what the facts are. They have to complete a satisfactory program to address medical protocol, community care, community clinic history and operations, medical administration, hospital operations and protocol, medical ethics, the California medical delivery system, health maintenance organizations, and managed care practices and pharmacology differences.
Your time is up.
Thank you.
We believe that our curriculum successfully does that, as evidenced by your consultant indicating that.
Thank you for your comment. Are there any additional comments from the audience? Okay. Thank you, gentlemen. Dr. Ree, please come forward.
Yes, thank you to the previous speakers for presenting that information. That was wonderful to hear and to learn about. I didn't realize there was so much involved with international correspondences and my own father. I mean, I grew up in a home where my dad was studied and failed the ECFMG 6 or 7 times in Chicago, so I'm very familiar with foreign medical graduates and that sort of thing. And so certainly I would just say to the board, look, so certainly diversity is more than just language. It's more than just language. It's more than just eating a different type of a dish from a different ethnicity. Diversity has, and especially in primary care, diversity is more than just speaking someone's language. It's understanding that culture. If a Chinese woman comes in, she's 80 years old, and she comes to you 10 times and says, I have a stomach ache, this not helping, that's not helping. Well, it turns out she was depressed, and that's culturally how they express it. So that kind of diversity, I'm wondering, might be left out in this training process for the physicians from Mexico. So if that could be addressed, that would be wonderful. That type of learning as far as cultural diversity. Undoubtedly, the English it's a language, and it's better than no training as far as racial diversity. But I would voice that it's not enough, not in the primary care office. Then the other point is that. I'm also actually deeply concerned about Mexico. I'm concerned that we're taking away their brain power. I mean, I'm not familiar with all the provinces of Mexico, but I feel bad for the Mexican people if we're going to take all their doctors. We don't need them as much as maybe they do. I would suggest to you. And then look, I'm just going to say it. We have to be very, very careful. We have to be very careful. For white races, we have to be very careful. When a white race is very vigilant, hyper-vigilant about their causes, there's a name for that. And so it's important not to marginalize non-white people, non-white cultures. We have to be very careful because we get so focused on our own causes and our own desires that we forget we live in California and on this planet. So for the patients who are not here, for the non-white patients that live in that area, I work extensively in the state of California, but currently specifically in the San Joaquin area. And there's a definite need for, there's...
Dr. Ree,
Yes.
please conclude.
Yes, thank you. So I would really, really caution the medical board about this trend or this desire. I'm not opposed to it. I really want you to maybe see a different perspective. Thank you very much.
Thank you for your comment. Are there any additional comments in the audience? Any comments on the phone?
Show no comments at this time.
Okay. Ms. Cruz-Jones, please take roll.
Dr. Bolat? Aye. Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson? Dr. Lewis?
Aye.
Ms. Sutton Wills? Mr. Warmoth?
Aye.
Ms. Wright? Aye. Dr. Yip?
Aye.
Ms. Pines?
Aye. The motion carries. Let's move to next to agenda item 20, update, discussion, and possible action and recommendations from the licensing committee. Dr. Kraus?
Thank you. The licensing committee met on Thursday, July 26th at 1 p.m. Ms. Alameda provided a licensing program update. The licensing program continues to process incoming mail within 7 days and review applications within 28 days. Effective July 1st, 2018, the expiration of a license is no longer based on birth month. Licenses issued now expire 2 years later on the last day of the month in which it was issued. The board's website has been updated to reflect this change, as well as board forms. The licensing program is participating in a pilot project with the International Association of Medical Regulatory Authorities to check their website for possible discipline information on individuals from other countries who apply for licensure. Ms. Alameda gave us a presentation on the changes to requirements for postgraduate training that become effective January 1st, 2020. The changes require 36 months of successful completion of board-approved postgraduate training for all applicants. A postgraduate training license will be required for each medical graduate who participates in an ACGME-approved postgraduate training program. Ms. Alameda provided an update on continuing medical education audits. The licensing program will increase the percentage of audits to 10%, which is an increase to 1,100 audits per month. In addition, the board issues an administrative citation and fine to a licensee or permit holder that certifies on their renewal notice that he or she completed the required continuing education requirements but was found to be non-compliant. The meeting was then adjourned. Thank you.
Thank you. Are there any comments or questions from the members? Oh, Dr. Hawkins?
So I agree with this 3-year postgraduate training requirement. And I think citizens of California will have more primary care, first, internal medicine, family practice, pediatrics. But I just wonder, and I'd like to get a little bit of input from those around the room. We have 2 new medical schools, at least in California. Are we going to be able to have adequate residency training programs for these physicians?
Dr. Gonadev?
Residency programs are expanding, but not fast enough. If you look at about 1,000 U.S. graduates did not match. But majority of the reason they did not match was not because there weren't enough residency programs, but because they were looking for programs which was beyond their reach. I'll give you an example. A dermatology residency requires 260 and above step 1 score. If you apply to dermatology at 230, there is no chance and you missed out everything. Several thousand international graduates still matched, especially U.S. residents who went to Caribbean, UK, and Polish schools, matched into the primary care programs. So it's not just even though if you add the international graduates, that's where we have bottleneck is residency programs. If you don't add the international graduates, we don't have a bottleneck in the residency program. So the only solution is like what we approved in tobacco tax, which this board supported, the CMA supported. $50 million was supposed to go to UC system to create additional residencies by anybody, not just to UC system. Unfortunately, that was given by the state of California to UC, but they took away $50 million elsewhere. So it's a wash. So there is a lot of work going on behind the scenes to create more residency programs, and you're absolutely correct. I think that's where the biggest bottleneck is.
Any other comments from members? Any comments from the audience? Any comments on the phone?
I'm showing no comments at this time.
Okay, great. Thank you, Dr. Kraus. Let's move to agenda item 21, discussion and possible action or recommendation from the Specialty Faculty Permit Review Committee. Dr. Bolat.
Thank you very much, and members, this will take a little time. We had two individuals that my colleague and I listened to for the Special Faculty Permit Review Committee. So on June 14th, 2018, the Special Faculty Permit Review Committee met, held by teleconference. During the meeting, the committee reviewed and discussed two applications: Dr. Rosa Bacheta's application for a special faculty appointment with Stanford University School of Medicine, and Dr. Romain Paraccio's application for a special faculty appointment with the University of California, San Francisco School of Medicine, and his appointment as division chief at Zuckerberg San Francisco General Hospital and Trauma Center. And if you will, you can review this on Agenda 21-1 in your meeting packet for a detailed report on Dr. Bacheta's and Paraccio's medical school and postgraduate training. Dr. Bacheta's area of specialty is in pediatrics, specifically in the area of genetic autoimmune diseases. Dr. Bacheta's clinical activities will focus on cellular and gene therapies for treatment of devastating genetic, hematological, and autoimmune diseases. Dr. Bacheta has held a non-tenured research position as Associate Professor of Pediatrics at Stanford School of Medicine since May 2015. Previously, Dr. Bacheta was appointed Associate Professor in Pediatrics at the Italian Ministry of Education, University and Research in 2014. Dr. Bacheta's original experimental work and high-impact publications reflect the unique expertise she has in applying functional immunology to genetics. Dr. Bacheta's scholarly work during the past 15 years, including research, has had a significant impact on the treatment of immune dysregulation, polyendocrinopathy, and neuropathy, X-linked patients. Dr. Bacheta developed the Pediatric Immunology Outpatient Clinic while at San Raffaele Hospital in Italy and established a new line of laboratory investigation into autoimmune genetic diseases while at this, as well as the therapy. If approved, the board, Dr. Bacheta will hold a full-time faculty appointment as Associate Professor of Pediatrics at Stanford. Dr. Bacheta's clinical duties will focus on cellular and gene therapies for treatment of autoimmune diseases and mentoring trainees, junior scientists, and physician scientists. Stanford has demonstrated that Dr. Bacheta is academically eminent to hold a full-time Associate Professor clinical faculty appointment at Stanford University School of Medicine, and there is a great need for her expertise in the field of medicine. The committee has reviewed Dr. Bacheta's application and qualification and recommends that the board approve Dr. Bacheta's for special faculty permit appointment. This concludes my report for Dr. Bacheta's. Are there any questions from the board?
Make a motion to approve.
Okay. Are there any comments from the audience? Any comments on the phone?
I'm showing no comments at this time.
Ms. Cruz-Jones?
Dr. Bolat?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton-Wills?
Yes.
Mr. Wormuth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Aye.
You
Okay. The
forgot
sec-
me.
Ms. Pines.
Yes. The motion moves.
Thank you.
Dr. Bullock?
Dr. Paraccio's area of expertise, this is our second applicant, is in anesthesiology and critical care medicine, specifically in the area of acute and critical care for trauma patients. Dr. Paraccio will bring his extensive experience to UCSF in caring for the acute and critical care needs of trauma patients and allow him to further advance the collaborative approaches to clinical care. Dr. Paraccio was previously a visiting associate professor at UCSF and currently holds an adjunct appointment in epidemiology and biostatistics at the University of California, Berkeley. Dr. Paraccio has been awarded the Best Clinical Research Award from the French Society of Anesthesiology and Critical Care Medicine and has diverse training in anesthesiology and critical care medicine, particularly in the care of acute and critical needs for trauma patients. Dr. Paraccio's extensive experience in the perioperative care of trauma patients and in designing clinical programs is clear. If approved by the board, Dr. Paraccio will hold a full-time faculty appointment as Professor of Clinical Anesthesia and Perioperative Care at UCSF and also serve as the Chief of the Department of Anesthesia and Perioperative Care at Zuckerberg San Francisco General Hospital and Trauma Center. Dr. Paraccio will provide patient clinical care and teach residents and students. He will be working closely with departmental and institutional leaders in advancing the departmental missions of providing outstanding clinical services at UCSF and its affiliated medical centers. UCSF indicated that Dr. Paraccio's background and expertise will allow him to further advance the approaches to clinical care, including in coordinating intraoperative and postoperative management with patients with limited social support resources. UCSF has demonstrated that Dr. Paraccio is academically eminent to hold a full-time professor clinical faculty appointment at UCSF and to also serve as the Chief of the Department of Anesthesia and Perioperative Care at Zuckerberg San Francisco General Hospital and Trauma Center. The committee has reviewed Dr. Paraccio's application and qualification and recommends that the board approve Dr. Paraccio for a special faculty permit appointment and to also approve him for the Chief of the Department of Anesthesia and Perioperative Care at Zuckerberg San Francisco General Hospital and Trauma Center. And this concludes my report for Dr. Paraccio. Are there any questions?
Can I have the motion?
I move to grant him the licensing status as recommended.
Is there a second?
I have a second, but Michelle, this board has nothing to do with his appointment at the UCSF for Zuckerberg Hospital. We can only give him special faculty permit. That's about it.
That is correct. I think during, and maybe Ms. Sutton-Wills will recall, there was just for the board's edification, there was some concern by the faculty at UCSF of whether or not this individual could in fact behold a department chair. So I'm not sure why that was in there, so maybe April, you have any comments on that, or?
The board does have to approve the appointment
Approve what, I'm sorry?
to that position.
It's in the law. Okay.
Learn something every day.
Okay.
Are there any other questions from members? Any from the audience? Any comments on the phone?
I'm showing no comments at this time.
Okay, Ms. Cruz-Jones?
Dr. Bolat,
Aye.
Dr. Gonadev,
Aye.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson.
Aye.
Dr. Lewis,
Aye.
Ms. Sutton-Wills. Mr. Warmoth,
Aye.
Ms. Wright,
Yes.
Dr. Yip,
Aye.
and Ms. Pines.
Aye. The motion moves. We're going to go out of order because I think we have someone on the phone. Okay, so we're going to go to item 24.
Okay.
The- Okay, go ahead.
Please refer to agenda item 24 in your packet. Upon receipt of information from the medical school, board staff conducted the initial review of St. George's University of London International Program, application and supporting documents. After review, staff requested board licensing medical consultant Dr. Nuevo to review the information to determine if the school met the requirements set in law and regulation. Based on Dr. Nuevo's review, he has determined the medical school curriculum meets the requirements for approval. Dr. Nuevo has also determined that a site visit is not necessary since the board currently recognizes the University of London St. George's Hospital Medical School and has also provided documentation and that they are in compliance with the regulations. Dr. Nuevo's report is in the packet. He was not able to attend, but we do have him on the line for the board to ask any questions and for him to also present his findings and recommendation.
Hi, this is Dr. Jim Nuovo. I'll be brief. This is just as an aside, this represents the 8th program that I've reviewed for the medical board. And in summary, after reviewing all of the documents, I believe that the International MBBS program at St. George's Hospital is in substantial compliance with the appropriate statutes and regulations that meets the requirements for recognition. The key issue in this review was that initially it was unclear that the program had sufficient resources for the training in the clinical years in the 3rd and 4th year. And after a consultation with the school and a conference call, it was clear that they also agreed that there were concerns about the initial facility that they were using in Chicago, and changed the structure of their clinical training to 2 sites, one being the Marshall University Joan C. Edwards School of Medicine in Huntington, West Virginia, and the other being the Jefferson University Sidney Kimmel Medical College in Philadelphia. These are both large programs that are Joint Commission, LCME, and ACGME approved, and have the resources and capacity to meet the training needs of the students from the St. George's Hospital Medical School. So after all of that review, I do feel that all the documents show that they're in substantial compliance, and I recommend recognition retroactive to the time that they began the training at these 2 institutions. Thank you.
I move that we recognize the St. George University of London as previously recommended by staff.
Do we have a second? Second. Great. Are there any comments from Dr. Ganamada?
Yeah, just a question. April, this was an established medical school in UK, but they added this program for the US students, I gather?
Yes.
Okay.
Okay, great.
And Dr. Nuevo, you interviewed the students also. How did you conduct I know you have faculty interview and student interview. What feedback did you get to the students that they were actually getting the education that they expected? Did you?
Yes, it was clear that this change of using the 2 institutions I mentioned, Marshall University and Jefferson University, are clearly a substantial change for the institution and clearly provide the kind of training that the board would expect for someone to engage in graduate medical education. So that became abundantly clear from our further conference call discussion with their institution.
Okay, thank you.
Okay, great. Do we have any comments from the audience? Any comments on the phone?
I'm showing no comments at this time.
Okay, Ms. Cruz-Jones?
Dr. Bolat? Aye. Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson? Aye. Dr. Lewis?
Aye.
Ms. Sutton Wills? Yes. Mr. Warmoth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Aye.
Ms. Pines?
Yes. The motion carries. Moving on to agenda item 22. Thank you.
Thank you. Goodbye.
Goodbye. A presentation on the Division of Workers' Compensation System from Mr. Raymond Meister. I would like to ask that Mr. Meister come forward. Thank you. Dr. Meister is the Executive Medical Director of the Division of Workers' Compensation. Prior to joining DWC, Dr. Meister served as Public Health Medical Officer at the California Department of Public Health for 14 years. He has also been a faculty member at the University of California, San Francisco, and is Associate Clinical Professor. Dr. Meister, you can begin.
Great, thanks a lot.
Thank you.
Morning, everyone. I'm Ray Meister, and as was just said, I'm the Medical Director at the Division of Workers' Compensation for the state of California. And thanks for having me here this morning, and it's going to be a little bit of a whirlwind tour here, so I'll go through these kind of quickly, and I'll hit the high points, and then we can have some questions if you have any. So I'm going to try and give you an overview today. I was asked to provide some statistics on workers' compensation claims in California. I'd like to talk about our MTUS, our medical treatment utilization schedule, and specifically the treatment guidelines that are part of that. We've also recently adopted a formulary. Then I was asked to give a little bit of information on our Qualified Medical Evaluator, or QME program. So going on to some statistics about workers' comp in California, this slide shows the number of new claims that we get on an annual basis, 2012 through 2017, and you can see there's been a slight increasing trend. Currently, in 2017, there were 673,000 new workers' compensation claims in the state. This slide shows the claim distribution for the state, and I think it's probably what most of us would expected. Kind of the larger population areas is where most of the claims are coming from. This slide shows the industries, the leading industries for claims, for workers' compensation claims. Some of the top ones are retail trade, healthcare and social assistance, and manufacturing. And you can see the rest of them and the percentages of the claims that they provide. As far as the age of a typical workers' compensation claim, the highest percentage involves workers that are between the age of 25 and 34. And again, you can see the numbers represented by the bar graphs for the rest of the population. Looking at male and female workers and the percentage of claims, the male workers are approximately 56% of the claims in the state. Here's a graph showing the general type of injury or illness that is involved in most claims. As you can see, the leading type is a strain or tear, followed by contusions, lacerations, sprains, and you can see some of the rest of them on the rest of the slide there. As far as causes for injuries in the workers' compensation system, this slide shows that. Lifting injuries lead the way at 9% of the claims. General strains, falls, slips and trips, and on down the line from there. As far as claim closure rates, they've been improving, but California has the highest proportion of open claims in the United States. And this, looking at claims that have been open for 2 years or 24 months, we are or recently at 46%. Whereas if you look across the country, 23% is where the median's at. At the last bullet shows some of the things that influence this. There's a high volume of medical lien filings. There are higher rates of permanent disability and cumulative trauma claim frequency in California compared to other states. And as you may know, sometimes things get very complex in workers' compensation as far as the handling and settling of the claims. So now I'll switch gears and talk a little about our MTUS, our medical treatment utilization schedule. And that blue book there contains some of the regulations that govern workers' compensation in California, and the MTUS is a part of those regulations. What it does is the regulations establish the primary role of the treatment guidelines in the MTUS. We also have something called a medical evidence search sequence, which I'll touch on a little bit, and also a methodology for evaluating medical evidence, which I probably won't go into, but I think it takes a little while to learn it and get used to it, but I think it's a very comprehensive way of looking at evidence-based medicine. And so if you have interest in that, I think it's well worth reading. The general principle behind our MTUS is evidence-based medicine, and currently the treatment guidelines that are part of our MTUS are the most current ones from the American College of Occupational and Environmental Medicine. So why is the MTUS important? We view it as the primary source of guidance for treating physicians, as well as for reviewing physicians working in workers' compensation in the state of California. Another thing about it is that by becoming familiar with the treatment guidelines, a physician can help to kind of smooth the way for the care that they want to offer their patients. The MTUS in its kind of current format came into being in 2007, I believe it was, and at that time the guidelines that were adopted were the second edition from ACOM, which had been put out in 2004. Until fairly recently, some of those same 2004 guidelines were in place, but at the end of 2017 we were able to update all of the treatment guidelines in the MTUS, as well as add some additional treatment guidelines. This slide shows the topics for each of the current guidelines that are part of the MTUS. And it's not listed on here, but we just recently, or we're currently in an adoption process to update a few more of these chapters, and ACOM also came out with a traumatic brain injury guideline, which we're in the process of adopting. I mentioned our medical evidence search sequence, which is part of the MTUS. The blue boxes on the left-hand side of the slide show the basic steps that are part of our medical evidence search sequence. What the MTUS advises is that a treating physician should first review the appropriate treatment guideline. We don't have treatment guidelines on everything. For instance, there's not a treatment guideline for cancer. There's not a treatment guideline for infectious diseases. So if the MTUS doesn't have the appropriate treatment guideline, then the physician should look for other treatment guidelines. There are other providers that put out comprehensive sets of treatment guidelines. Obviously, there's medical societies and all sorts of folks across the nation who are putting out guidelines. So that's kind of the second and third step. And then the fourth step would be to go out and look at the medical literature at large. Assuming that it's one of the more common workplace injuries or illnesses that we see, there's a high likelihood that it's going to be covered in one of our guidelines. And then you would switch over to the right-hand side of the slide where the yellow boxes are, and you would look to see what the recommendation is for the condition that you're treating that patient for. If you agree with that recommendation, it should be a pretty straightforward process. You know, you apply that treatment guideline, that recommendation, and everything should be in sync. Again, there are going to be times where we don't have a treatment guideline, or there's going to be times where a treating physician says, I see what the guideline says, but I think there's a better treatment out there. Again, that's when they would kind of go down to the second, third, or fourth steps of our medical evidence search sequence. And then they would find something that they feel is of a higher level of evidence that supports the treatment they want to provide for their patient. And they would submit that. I'm guessing that everyone here knows what utilization review is, but just real briefly, when a treating physician has a treatment plan in workers' comp, they will fill out what we call a request for authorization, or an RFA, where they list the treatment that they would like to provide for the patient. That request, along with the clinical documentation for that individual patient, will go to a utilization review physician, who is then supposed to look at that, the individual information for that patient, look at the treatment guideline that's either part of the MTUS or that is other guidelines out there that, as necessary, and then they make a decision, is this treatment medically necessary for this patient? Also up there is, I have listed the IMR, or Independent Medical Review Physician. If a UR physician either says no to that request or somehow modifies that request, the injured worker then has a right to request basically a second opinion, an independent medical review. And that's a program that we're responsible for, where it goes to another physician, for review. I basically already covered this, but this just again talks about the two situations where they may go outside of our treatment guidelines. And again, that's either if they don't agree with the treatment that's in the guideline, or if we don't have a guideline that covers that condition. So again, this is a set of regulations. It's important to know that there's the treatment guidelines that are part of the MTUS have a presumption of correctness in our program. Again, it's hopefully a way for treating physicians and reviewing physicians to kind of be on a level playing field, if you will. Advice that we always give to treating physicians is really try to give good documentation and support for the treatment you're providing, especially if you can show that your documentation matches up with the recommendations in the treatment guideline. Again, everything should go pretty smoothly. And we do have, when UR denials happen, we do have the independent medical review process as well. Just since I had some recent statistics on our IMR program, I thought I would briefly discuss those. On the right-hand side of the slide, you can see that shows how many FDLs, or final determination letters, the IMR program has put out. So, you can see it's in the range of 140 to 180,000 decisions a year that get reviewed through the IMR process. Here we're looking at a monthly, the monthly numbers, and again, the rough monthly number is 15,000 IMR decisions that get put out a year. We do have some guidelines for how, the idea is for this to be a fairly quick turnaround. So the black line that's kind of hovering around 30, that's the number of days from the time that the IMR process starts. And the the lower line that kind of hovers between 10 and 14, that's the number of days that it takes the IMR reviewer to get the decision out once they have the complete set of medical records, which is a little bit of a limiting factor. And so that usually within 2 weeks of getting the records, they have a decision out. This slide kind of mirrors, I think, pretty closely the one that we saw earlier. This shows that what regions of the state the greatest numbers of IMR decisions are coming from or being generated from. So again, Los Angeles, the Bay Area, et cetera, are, I think, primarily where you have the large population centers. This slide shows some general categories of where the what topics the IMR decisions deal with. And again, these all start as a utilization review denial. You can see pharmaceuticals at 43% are the largest chunk of the pie graph here. Rehabilitation, physical therapy, that sort of thing, diagnostic testing are some of the other larger categories. This slide shows the uphold and overturn rates. In IMR language, an uphold means that the IMR reviewer agreed with the utilization review decision. An overturn means that they disagreed and have overturned that decision. You can see there is some variation, but the average percentage is about 9% of the utilization review denials that go to IMR get overturned. So I've briefly covered our MTUS with its incorporated treatment guidelines, and then a little bit on UR and our IMR program. Just recently, we added a formulary to our MTUS. This was a legislative mandate, and it took us a couple years to get it in place, but it's now in place as of January 1st. I mentioned that all of our treatment guidelines are ACOM treatment guidelines. ACOM also has a formulary which goes along with those treatment guidelines, and so that formulary, which coordinates with our treatment guidelines, was kind of the starting point for our formulary. And we have something called our MTUS drug list, which is a subset of medications, and all those medications are the ones that tie back to a treatment guideline in our MTUS. And then we have some additional formulary rules, which I'll touch on really briefly. Sorry this slide is so small, but this is the basic format of our MTUS drug list. This is available on our website, for anyone to see. I'll call out some of the key features on it. Drugs are listed by drug ingredient. One of the key things that we've added to each drug is whether or not it's an exempt medication or not. And in a nutshell, to be an exempt medication on our MTUS drug list, a medication had to be safe and effective, and it had to be recommended for the acute phase of treatment in kind of a typical workers' compensation injury or illness. So our idea here was to try to speed the delivery of these medications early on in the treatment to the injured worker. If a drug is labeled as exempt, and if it's used in accordance with the treatment guidelines, then there should be no utilization review on that. It should just go directly to the patient. We also, another column in our MTUS drug list is the reference and guidelines column. So for each drug ingredient on our list, we have a listing of all of the ACOM ACOM treatment guidelines, which discuss the use of that medication. And we have a little key. A check mark means that somewhere in that guideline you'll find a recommendation for the use of that drug. An X means that you'll find a recommendation for not using that, against using that drug. And the circle with the slash means that you'll find that some drugs, there's not enough evidence one way or the other, so it falls into this kind of middle category called no recommendation. And some people have told us this is confusing, but our idea was to try and give a snapshot. Obviously, what a clinician has to do is they have to kind of dig into the guideline and that specific medication recommendation to see whether it's actually appropriate or not appropriate for the condition that the patient has. If a drug is not exempt on our list, it's non-exempt. And the non-exempt drugs in general are the drugs that are going to be used in the chronic phase of an injury or an illness, or perhaps it's a drug with a higher risk profile. For instance, all opioids are non-exempt medications. It doesn't mean, non-exempt doesn't mean that there aren't supported uses for those medications, but it means that they're not going to typically be the first line medication that you're going to use in the acute treatment of a patient. Recognizing that sometimes some of the medications that we've labeled as non-exempt may actually be needed urgently at that first visit, we've created what we call a special fill category of medications. So using an opioid as an example, if someone comes in with an acute injury and is in severe pain, the special fill provision would be used to allow the physician to supply an immediate prescription for that medication. And typically our special fill period is up to 4 days of the medication. I'll be real brief on the spotlight on opioids, since I think I'm sure all the board members are very familiar with this, but unfortunately these headlines are all too frequent these days. This is just a screenshot of what the online version of the ACOM treatment guidelines that we use looks like. This is the recommendation in the guidelines for opioids for acute pain. I've cut and pasted this out of that recommendation, and I'm sure all of you are very familiar with this, but the CDC recommendation is that 3 days or less of an opioid are often sufficient for the treatment of an acutely painful condition, and that 7 days will rarely be needed. You may have all seen this kind of follow-up study that came out in March of 2017, where they were looking at folks that had never received an opioid before, and then looked at those same folks and whether or not they might still be on an opioid a year later. And they found that the chance of being on an opioid a year later started increasing as soon as the 3rd day, and had sharp increases after the 5th day and the 31st day. So it appears that risk is happening very quickly, and just in those, anecdotally, I was told that in years past, a 3-week prescription for opioids was fairly common as kind of the initial prescription. And looking at these numbers, you can see that would be of concern. Similar to the special fill provision, we also have a perioperative fill provision. We realize that sometimes around the operative period, a medication needs to be changed urgently, or a medication that maybe wasn't initially thought to be needed might be needed. So again, some of our medications have a perioperative fill designation. Real briefly on some of the other things of our formulary, there's no FDA drug that's not allowed or that's not on our formulary, if you will. The most significant thing that a physician is going to have to do is request the medication and go through the utilization process, as has pretty much always been the case. It's important to note that things like HIV prophylaxis, that's kind of exempt from our formulary, and so there are certain things that we don't cover. We as part of our formulary, have a pharmacy and therapeutics committee. We just got this panel of 3 pharmacists and 3 physicians selected, and we're going to be meeting in a public meetings starting in September. So we look forward to their input and suggestions on improvements that we can make. Shifting gears to the QME program, this is the QMEs are physicians that are actually certified through us at the Division of Workers' Compensation. The basic requirements are that they have to pass an examination that we administer. It's actually a fairly comprehensive examination. There's a relatively high percentage of folks that don't pass it. It's that this medical legal arena is not kind of what most of us learn in medical school and stuff. So there's a lot to know if you want to be a QME. Once someone passes the QME test, they then have to take a 12-hour report writing course. The reports that QMEs put out are medical legal documents, and there's a very specific format and information that needs to be covered in these reports. Not unlike the medical board, we have QME continuing education that's required. They have to do 6 hours a year. And we also accept complaints and do quite a few investigations of QMEs, for a whole variety of reasons. So that's my brief report on workers' comp, and I'm happy to
Thank you,
try and
Dr.
answer any
Meister.
questions.
Are there any comments or questions from the members? Dr. Kraus.
Thank you, Dr. Meister.
Sure.
I'm wondering if you could touch on fraud and abuse. I know nationally one statistic I read was 7.2 billion in workers' comp, which means California would probably be close to $1 billion. And when that's investigated, does the board receive notice of fraudulent physicians only after there are criminal charges? Or is there some other mechanism of relationship between your division and the medical board?
So I'm certainly not the most knowledgeable person on this at the DWC, but some of this is from recent emails with Kim. But I think that we are, and I'm not exactly sure where, but we are supposed to be telling you of the physicians that get suspended. And as you may all know, over the last couple of years, the DWC has really had a focus on fraud, looking at some of these lien claims that get filed, at reviewing physicians who have issues either in workers' comp or in other areas of medical care. So I don't know what the specific rules are as far as when we should be telling you, but I know we should, and I think recently we sent an update, and I'm assuming that we will be more on top of that in the future.
Right. Dr. Bolat?
Thank you, Dr. Meister. This presentation was very important, and I think it's important for several reasons. One, the point that Dr. Kraus just mentioned, but the fact is there, as your data suggests, 25 to 34-year-old people in the prime of their lives, have had in the past not, access to appropriate treatment, not under your agency, but just in general, because it's a group that, they're working hard, then they're out of work, and then we know the statistic that if someone goes to a doctor and they write time off, then, it's hard to get back into the workspace. But my interest is a couple of things. One, I am aware that the cures that your doctors are putting in, your PTPs are putting in, using the cures database. I think that's very important. And I think the other piece is the communication, because we talk about all of the issues that occur when people are just in the commercial world or, not inside the workers' comp, but you layer it, workers' comp patient, 30-year-old or a 50-year-old, whatever the age, and they have all of these other medications. Just trying to understand the picture of that patient is very challenging and very important. So since you're new, and this is a brand new day for DCW DWC under your leadership, can you give us kind of the vision of what you see some of the challenges are, the opportunities that you're going to bring to patients are in California?
Sure. Well, I certainly hope that, and I expect they are, but I certainly learned that you need to, if you're taking care of someone, there are certain things that you need to ask about, including their past medical history, including their medications, that they're on. I mean, you can't just, in my mind, a physician should know about all those things and not just, focus on, in this case, a work-related injury or illness. I would hope that most physicians share that experience and feel that's important. Having the MTUS and having current treatment guidelines, again, I hope that's something that can that's a positive for our system and something that can be both an educational tool and something something that is going to make the system work smoother for people, because delays in treatment certainly aren't good primarily for the worker, but they're frustrating to the healthcare providers and everything else. I guess do you have any kind of certain suggestions? I mean, like I said, I guess I see it as just kind of a primary thing that a physician should do, and
I can respond to that. I think that what often happens with the injured worker, they see themselves in two separate systems. They see themselves underneath the medical legal system of the injured workers or workers' compensation, and then they go see people like me and their subspecialists. And oftentimes, what is happening out there is that if myself, I won't know what the patient's medications are. There's no communication, and the patient really doesn't really see that. People don't think about drug-drug interactions and so on. So I think my concern is open lines of communication. I think from the fraud point of getting that information back to the Medical Board of California, because we're here to protect consumers. And that, to me, has always been a kind of a missing piece. We're all in this together, so we want to bring that consumer underneath an umbrella of high-quality, efficient, and effective care without these delays in treatment, because that's often, I think, has been my experience, and I can only speak for myself and not my other members of the board. So I was pleased to see that, we have this knowledge that there are doctors out there doing this. And I guess my final concern are, who are those IMRs? Are those crossing state lines? How does that independent reviewer come into there? Is that somebody in Texas? Is that somebody in Nevada? Who's making those determinations for the IMR?
Sure. So the IMR and also this same would apply for you, our physicians. Our regulations have it so that they have to be California licensed, but they don't have to reside in the state of California. I think as much as is possible, the attempt is made to have these decisions, be made within the state, but that's not always the case. Another thing that we sometimes hear concerns about is the matching or not matching of the specialty of the requesting provider and the either utilization review or IMR physician. And our regulations basically say that the reviewing physician needs to be knowledgeable in the treatment that's being requested, but not necessarily of the same specialty as the requesting physician. And also, just so I don't forget to say it, if, I certainly am interested, and I think I can speak for others at the DWC that, if you or anyone else have ideas about, how we can coordinate on some of these things or improve some of these things, we'd certainly be interested.
Thank you. Did you? Okay.
I just wanted to let the members know that it's nice to, I reached out to Dr. Meister through the CDPH work group that we're on, and so asked him to do a presentation here, but also just talking about the law, I think it passed 2 years ago, that requires the DWC to notify the medical board of actions that they take. So now that we have that open communication back and forth, so we've been in receipt of our first group of physicians, because we were talking about, where we see it is in the newspaper. Well, we want to make sure that we get it before the newspaper, and so it's something that we will definitely work with, the two of us being able to get that communication going back and forth on a regular basis.
Dr. Yip, did you still have a comment?
More like, thanks for coming, more like for education, the statistic, the leading industry for claims, are those like solid number, but not percentage of the workforce, right? I'm understanding like law enforcement are quite high in the claim for work-related injury, but they're not listed there. Is it because of small number or actually the percentage of the workforce?
Well, to tell you the truth, I don't know enough. I asked for those statistics, to be pulled and for those slides to be made, but I don't know. I don't have enough background on that to answer that. If I could certainly find that out though and try and get back to you on that.
Ms. Webb?
Dr. Meister, I just wanted to clarify something because we did a review on utilization review physicians and MR physicians. IMR physicians, and determined that the law does not require them to be licensed in California.
No, yeah, you're right on that. Sorry, I think I misspoke. Yeah, so it doesn't, right, so they don't have to be licensed in California. That's correct.
Thank you. Are there any additional questions from members? Any from the audience? Any on the phone?
I'm showing no comments at this time.
Okay, thank you, Dr. Meister.
Thanks.
Okay, moving to agenda item 25, update from the Department of Consumer Affairs, which may include updates on department's administrative services, human resources, enforcement, information technology, communications, and outreach, as well as legislative, regulatory, and policy matters. Mr. Lee.
Good afternoon. President Pines, Vice President Lewis, Executive Officer Kirkmeyer, and members of the board. Well, first of all, thank you again for another opportunity to provide an update from the Department of Consumer Affairs to your board. As I'm one of the last agenda items, I'm happy to report that my update will only be 2 hours long. Just kidding. For the record, my name is Patrick Clay. I'm the Assistant Deputy Director for Board and Bureau Services at the Department of Consumer Affairs. Before I begin, I'd like to congratulate the new board officers on your election. We very much look forward to be working with you. And as always, if the department can serve as a resource for you, feel free to absolutely reach out at any time. My first update is regarding the Director's Leadership Call, and as President Pines mentioned in her report yesterday on June 25th, the Director had his first Board Member and Advisory Committee Leadership Teleconference. We had over 30 participants in that telephone call, which included Board Presidents, Vice Presidents, Chairs, and Vice Chairs. During the call, DCA provided updates on Pro Rata, Assembly Bill 2138, the Executive Officer's Salary Study, and improvements to the regulatory review process. With the initial success of the teleconference call, we plan to host another one in the near future with a date to be announced soon. My next update is regarding the licensing and enforcement work group. Back in April, the department hosted its first licensing and enforcement work group meeting. We had over 60 staff in attendance. We convened executive officers, bureau chiefs, and key licensing and enforcement staff and began to identify business processes that will help strengthen our boards in the areas of licensing and enforcement. Since then, the work groups continue to meet on a monthly basis to discuss specific ideas to innovate in the areas of licensing and enforcement. So for example, in June, the licensing work group heard from Dr. Joseph Morris at the Board of Registered Nursing and learned about BRN's Cloud Drive technology and ways that the platform can streamline license application processing. My next update is regarding the Substance Abuse Coordination Committee, which was covered a little bit in the Executive Officer report. As you recall, back in April, the department reconvened the Substance Abuse Coordination Committee. Per Senate Bill 796, the committee has been tasked with re-examining Uniform Standard Number 4 related to drug testing standard for substance abusing licensees. The committee has been tasked to determine if the existing criterias need to be updated based on recent development in technology and research and to report to the legislature by January 1st of 2019. At its last meeting in June, the committee examined Uniform Standard Number 4 and took an in-depth look at drug testing methodologies, research, and technological advancement. The committee heard from a panel of industry experts in the field of rehabilitation, toxicology, and laboratory science. The committee voted to adopt some minor technical changes to Uniform Standard Number 4 and decided to further examine the issue of testing frequency at its next meeting with a date to be scheduled soon as well. My next update is regarding board member orientation training, which may be relevant to the board members who've been reappointed. The department has additional dates for board member orientation training for 2018. As you know, it's a one-day training in Sacramento, which details the important responsibilities of board members. BMOT is required within 1 year of appointment and reappointment to the board. The next two trainings will be September 18th and December 5th, with additional dates for 2019 to be announced soon. Registration is available online, but if you need assistance registering, we're happy to help facilitate that process. And my last update will be a legal update. The department wants to reiterate its commitment to continuously improve our regulatory review process. As you know, the department changed its processes back in 2016 to improve the quality of the regulations we submit to the Office of Administrative Law and reduce the number of disapproved files. We are happy to report that since September 2016, there was a steady improvement in the disapproval rate, going from a 21.8% disapproval rate in the first half of 2017 to only 7.6% being disapproved between July 2017 and February 2018. In 2018, there has been zero disapprovals. However, the department recognizes that at the same time, the time frames for review have also increased. So in order to reduce review timelines without sacrificing quality, the department has or is implementing the following 5 steps. Number 1 is training. As you know, regulation development is a collaborative effort between the boards and the department. So to improve the knowledge base of those writing regulations, the department offered 3 separate training classes to regulation staff, one in November 2017, another in April 2018, and another one in May 2018, to better equip staff with preparing rulemaking files and cut down on the level of scrutiny needed to review packages. The second step is that the department has cut layers for review. So we've cut duplicative layers that did not harm the quality of the rulemaking files. Third, we've done some internal restructuring, so the department consolidated review functions to reduce the amount of time lost due to transferring files throughout the department. Fourth is an agency attorney. The Business Consumer Services and Housing Agency hired a new attorney to help improve their review of regulations. And finally, the department is working on a computer tracking system. So the department will be developing a DCA-wide regulation tracking system to better manage time and better manage the way we track packages as they move through the department. We are confident that these steps will improve the review timelines, and as always, we are open to your feedback both at the board level and at the staff level on ways that we can continue to improve our review timelines. So this concludes my update, and I'm open to any questions that you may have.
Thank you, Mr. Lee. Are there any questions from the members? Dr. Gananodev?
Mr. Lee, thanks for coming. Thank you for the update. There has been a little difficulty in getting the finance reports, our income statement, our cash flow. Can you tell us why it should be so difficult for us to get it in time?
Sure, absolutely. I totally understand the frustration. As you know, the state has been moving to a new accounting system, Fiscal, so we're kind of all on board. It's a problem that other state agencies have faced as well, but we continue to work with the Fiscal system to make sure that as they roll out this technology that we're able to get the reports that you need to operate. If you'd like, I can follow up with our budget team to make sure if there are alternatives that we can provide to you in the meantime.
Yeah, please do, because we want to make sure that all entities we pay, we are within the budget. Thank
Absolutely.
you.
Thank you. Are there any questions from the members? Any questions from the audience? Any questions on the phone?
I'm showing no questions at this time.
Okay, thank you.
Thank you so much.
Thank you, Mr. Lee. Agenda item 26. Our October meeting is in San Diego. Do any members have any agenda items for the October meeting? This is a first. Oh.
There was a request on the MES issue. I don't know if we can explore that and consider agendizing it.
Can we use our mic?
Yesterday, there was a request from a member of the public on MECSF initiative.
Oh, this.
Chronic fatigue.
The fatigue syndrome issue.
Okay.
And so, if we don't have another public presentation, that could be slotted in potentially.
Okay, thank you. Any other? Nope. Okay. Are there any public comments from those in the audience? Ms. D'Angelo?
Thank you. Excuse me. Julie D'Angelo Filmuth from the Center for Public Interest Law. I think it was very illuminating for this board to hear from those two wonderful investigators yesterday. And I have a suggestion for a follow-up presentation. And it's actually a presentation that was done in front of Dr. Yip's Enforcement Committee earlier this year by a supervising deputy attorney general and a supervising investigator on the vertical enforcement process. It was very, very well done. And I even mentioned to Ms. Kirkmeyer that I thought it should be required viewing for all new board members and all new enforcement staff. So I think it would benefit the full board to get that presentation that Dr. Yip's committee got. Thank you.
Thank you. Are there any other public comments? Any comments on the phone?
Yes, there is a comment from Eric Andrews. Your line is now open.
Sorry, I couldn't hear the beginning of this particular thing. The sound the last 2 days has been really, really bad, at least for the callers. I don't know what it's like there in the room. I just wanted to say, as far as the agenda goes, I would like for the 8th time, I am requesting that you put on the agenda that we talk about the Public Records Act and how the medical board violates it. Please put this on. Aren't you tired of hearing me ask for it? Just put it on. Let's talk about it. I don't know what you're hiding. All right, thanks.
Thank you. Okay, the next agenda item is adjournment. Thank you.